Kali na? Tinta. Made prisoners. Well, the maybe for which Abhi Kete filed. Well, two writ appeals was filed on 3rd May. Tomorrow, madam. There's some urgency.
Listing.
Tomorrow, madam. Listing.
Listing, all listing allowed.
Well,
Mr. President.
There are two urgent writ appeals. We file it on 23rd.
No, Mr. Mojumdar, all listing allowed.
Tomorrow, ma'am.
Just give the memo to the.
I'll take to you.
Daily list for motion item 1 and 2.
What is it?
Yes.
but
We wanted to hear this matter
logic.
on the implication of para 97 of Muslim Mandal.
Muslim. So,
I think it will take a little time. Why don't we take up at the end of the list? Even the counsel for the petitioner is not present now.
logic. Logic.
Because
Last,
this is an issue of general importance.
so,
We hear it.
Logic.
And if somebody wants to address on this issue, you are also welcome, even if you're not there in the matter.
Item 3.
May it please your lordship.
Yes,
Lordship,
Mr.
I have
Sharma.
yet to get the information, lordship, instruction. Lordship, may I pray? Matter may please be taken up after 2 weeks.
What instruction you want?
Lordship, this regarding linkage, lordships. That last time the matter came up,
Mr. R. Sharma, learned counsel petitioner, seeks for an adjournment to provide the information as required by the order dated 1/3/2023. How much time you want?
after 2 weeks,
List after 2 weeks as prayed for.
highly obliged.
Item 4 for admission.
Mr. Manjur Bhuiya.
May it please the Lord. My lord, the verification report is there in the lower court records, which may be seen kindly at column number 5. The place of birth of the petitioner is written at Juria in a.
And what is the date of the birth indicated?
Before 1965.
Before, what is the date of the birth?
It is also recorded there in the verification.
Please check up and tell us.
Yes.
Please tell us the date of birth.
I have not verified it, my lord, only it is there.
Please verify it. Yes, Mr. Manju.
It is 1957. 1957.
27.
57.
57. Okay. Yes, who appears for the government of Assam?
Yes, lordship.
Why was this person referred to the tribunal? If he is born in 1957 and in a place in India, why was this person referred to the tribunal?
Yes, lordship, but it is only his statement, lordship.
No, it is your recording.
Record, but record it is stated that he could not furnish any document, lordship. Documentary evidence produced in column 14, Lordship, it is written as a documentary evidence produced as nil.
So that is the reason. Any document to show your date of birth. They have referred you because you did not produce any document
As
which
they
may
say.
indicate the date of birth.
As they say,
Please.
that place of birth is there admitted.
Uh-huh.
It is not
May be-
denied.
May be admitted, may not be admitted. First, on your date of birth, any document to show your date of birth,
Illegal- No, my
you don't have, then that's why they disbelieve it. That's all.
But-
Now, argue on that is otherwise.
that admitted that place of birth is that
They have not admitted, they have recorded. what-
recorded.
Mr. Major Bhuiyan,
What's here?
para 5 is this recording of your statement. But they also want that this facts narrated in para 5 should be substantiated by you. You did not produce any document to substantiate that. That is their case. Nothing is admitted.
My father's name is also there, the village name is also there,
Sorry,
everything
no,
there.
I think this argument cannot be accepted. They are the primary authority to verify whether you are a citizen or not.
Yes.
When they asked you, you said your date of birth is 57. When they asked you where were you born, you said it is Judea. But this is only your statement. They want materials to verify whether your statement is right or wrong. And
But
you,
it is
and you
verification.
failed to produce any document, therefore it is referred.
But it is verification report.
Nil.
Yes, you please argue. If that is the only ground, we have
No,
to reject it.
Not on the ground. This is
Are
one
you-
of the grounds.
Yes, please argue on your next round.
Other grounds, my lord, legal grounds have taken that the inquiry authority, as the verification officer has submitted, there is no provision in the Foreign Acts Act 1946 as well as in the Foreign Acts Order 1948 for verification by a police officer. The law is that all inquiries must be made by civil authorities as defined in section 2 of the clause 2 of the Foreign Acts Order 1948.
Foreigners Order 1948. Okay.
Clause 2, the definition clause, subclause 2. And
Just a minute. Which clause you are referring?
clause 2,
Clause 4,
clause 2,
clause 2.
definition clause. First
Defi-
one is registration officer,
Hmm.
second is civil authority,
Hmm.
as may be appointed by the central government. The section 5, clause 5A of the said order specifies that the civil authority may examine any person who seek to live to enter India, seeks leave to enter India or to depart therefrom, or during his stay in India for the purpose of the Foreigners Act 1946 or any order made thereunder. And it shall be the duty of the every such person
But
to
this is applicable to any person who seeks leave to enter India
yes,
or to depart therefrom.
or
You don't, this
or during his stay. If I am a foreigner,
or during a stay for the purpose of Foreigners Act.
yes.
So,
So I am proceeded against under the Foreigners Act.
yes, under which section is the inquiry made, Mr. Sharma? Is it made under section 5A or some other provision is there?
Yes. And no authority in Assam has been declared as civil authority except the airport authorities.
So, Mr. Major Bhuiyan, your submission is that all the references made
Yes,
for the
yes.
last 20 years or 30 years
But this is,
are without jurisdiction.
Yes, sir.
That, okay, we'll decide the issue.
Lordship. My lord. Regarding inquiry, Lordship, this aspect was gone into by this honorable court, Lordship.
Sorry.
Regarding inquiry, Lordship,
Huh.
this aspect was gone into by this honorable court, Lordship, in a case, Lordship, WBC 4989, a series of cases, Lordship, of 2016, Lordship. Detailed
Actually,
order. has
court,
been
it is
passed,
a,
Lordship. Yes,
it's a court-made provision.
yes, no, Lordship. Where inquiry.
Mr. Sharma, his argument is that these inquiries are governed by section 5A. And under 5A, inquiry can be made only by a civil authority, and civil authority is a defined concept. It cannot be done by the police. That is his
But
submission.
here, Lordship, police inquiry is not done, Lordship, here.
No, then who had done the inquiry?
ERO has done the inquiry, Lordship.
ERO is
Local-
also not a civil
Civil-
authority. Mr. Bajar Bhuiya, if this is the case, why this issue was not raised for the last 20-25 years? Why suddenly it cropped up today in your mind? You must have,
Also, although I,
Mr. Bajar Bhuiya,
Yes.
you have yourself attended
yes,
maybe hundreds of such matters. Why this argument suddenly appears today and it was never thought of earlier?
but I'm raising it now. my lord.
Okay, we'll decide it as you have
Yes,
raised, no
yes.
difficulty.
And another verbal submission, although it is not in my
Are you ready, Mr. Sharma?
petition.
Lordship, not the.
Mr. M. H. Majar Bhuiya, learned counsel for the petitioner, has raised an issue that inquiry preceding a reference made to the foreigners tribunal can only be made by a civil authority as provided in section 5A of the Foreigners Order 1948, where civil authority is defined under section 2(2). In the instant case, the inquiry had been made by a police authority, and therefore Mr. Majar Bhuiya raises a question of jurisdiction. Mr. G. Sharma, learned counsel for the Home Department to the Government of Assam, seeks for an adjournment to examine the aspect list after 1 week.
My lord, I have got another verbal submission. That the Foreigners Act 1946 is not applicable in respect of a person who claims himself to be a citizen of India or who is a suspected person. It is only applicable to foreigners. This is my submission.
List after 1 week.
1 minute.
And this has not been decided by any court, including the FIC.
Item 5,
Yes, Mr. Nath.
Where this. This is a contested matter, my lord. Your lordship will find the on earlier occasion, my lord, one case was referred before the FT Dubli. And your lordship will find page 22 is a judgment,
20,
The- page 22.
22.
By that judgment, the petitioner was declared.
This was an earlier reference.
Earlier reference, my lord. He was declared,
Ibrahim Ali, son of Sahar. And where is the present reference?
present reference, page your lordship will find, page 32. It is mentioned, my lord, in page 33, the judgment of earlier reference as exhibit B, which was not considered, my.
Yes. Yes, Mr. Nath.
So, my lord,
No, there is a subsequent reference.
subsequent reference is that, my lord, although he has produced 1971 voter list of his father and his voter list of 1979, that was not considered on the ground that his father's name was recorded as, my lord, Samsud Ali Munshi. The title was not telling.
Mr. Nath,
Yes,
is your submission that this subsequent one is barred by res
yes,
judicata?
yes, my lord.
That
Barred
is
by-
your submission.
Yes, my lord. Barred by res
Or
judicata.
you want to establish in the present proceeding that you are a citizen,
No, my lord, I am on barred by res judicata.
res judicata.
Yes, my lord.
Where is the subsequent reference?
Subsequent reference, my lord, order illustrable fine,
Page number
page 32.
32.
That is before the Tribunal Kamrup Metro.
Mr. Nath, is the earlier opinion a reasoned opinion? Is there any decision?
Yes, my lord.
Where is the decision?
Yes, illustrable fine.
No, I have read the order, but where is the decision? Decision means reason. Where is the reason? Mr. Nath, we asked you this question
Yes, yes, Lord.
in as much as the res judicata is between the same parties and must be decided in an earlier proceeding.
Yes, Lord.
Decided means a decision supported by reason.
Yes, my lord.
When the earlier opinion did not contain any reason, is it a decision under the law? Please submit on that.
My lord, it is on merit, my lord. And reason and also under the CPC, my lord, it is, that should be decided on merit. And it is
No,
opinion,
We do not agree with it. Merit supported by reason. If you read the order at page 22, no reason is noticed. He only writes seen so and so, seen so and so, seen so and so. Then ultimately writes, obviously I find him to be a genuine
yes, my lord, it
Indian
is a
So this is not a reason.
two-page opinion.
Reason means
Yes, my
this
lord.
document indicates that the either the father or the proceeding is a citizen and therefore I declare him. That is absent, that reason. So we discard the res judicata. You argue on the merits, you refer to some 71 voters list, where is it?
Yes, my lord. Illustrable fine, 71 voter list at page. Page 14 illustrable
Page
fine,
14,
page 14, my lord.
14. Saharuddin Munshi.
Yes, my lord. This is the father of
son
the,
Latifullah. Of which village? Village Binda Chora, part 4, Dhubri. Any document to show that Saharuddin of this list is the
Yeah.
father of the president?
yes, my lord, page 15
15.
is my voter list, my lord. Here it is written, my lord, I am Ibrahim Ali.
But
my
this is,
son, Sohar Ali, my lord.
we understand that, but this is of a different village. 71 man is of village Binna Chora,
Ah,
and 97 Ibrahim Ali, son of Sohar, is of village Dubirpara.
Dubilpara, yes, my lord.
So they may not be the same person. Any further material to show that they are the same person?
Yes, my lord, you will find. That is also Dubirpara, 1997.
That Saharuddin Munshi and Sohar Ali of the 71 and 97 voters list, that they are the same person, any material to show? Mr. S. Nath and counsel for a petitioner seeks for an adjournment to explore whether any further material is available which may indicate that Sohar Uddin Munshi, whose name appears at serial 311 of the voters list of 1997 of village Binnachara Park 4, Dhubri, and Sohar Ali, who is indicated in the voters list of 1997 of village Dubirpara, are the same person. How much time you want? 1 week? Just after a week.
Item 6.
Mr. Hawk.
Lordship, in this case also, Lordship, I raised the point of raised judicata, Lordship. And earlier,
Yeah,
Lordship,
where is the earlier opinion?
earlier opinion, Lordship, page 57, Lordship. And already I approached the raised this issue earlier, Lordship, the case of demanded back, Lordship. Can I have to come, Lordship? 57 is. There also village, father's name, all are same, Lordship.
Mr. Hawk, these voters list of 66, 70, 77, they are of the same village.
Same place, Lordship. Take
And
out
the
same-
petitioner is also from the same village.
Yes, yes, Lordship.
Yes, Mr. Sharma.
Lordship, remanded. The matter was already remanded.
To reappreciate this aspect again, Lord.
No, this is in the earlier opinion. So he is claiming res judicata. And this is a reasoned
Reason
opinion.
order, Lordship.
It's a reasoned opinion.
Yes, Lordship.
Right,
Lord-
wrong, we are not examining, but
Yes,
this
Lord.
is a reasoned opinion.
Yes,
So
Lord.
once there is a reasoned opinion in his
Then
favor,
judicata will apply, Lord.
the second reference will be,
But
Not
the
material in
judicata-
law.
yes, Lord.
so we allow the petition. Third, Mr. S. Hawk learned counsel for the petitioner. Also heard MSL Devi for respondent number 1, being the Union of India, and 6 NRCs. NRC authorities under the NRC. Mr. G. Sharma for respondent number 2 and 5, being the authorities under the Home Department, Government of Assam. Mr. A. Ali, learned counsel for respondent number 3, Election Commission of India. And your name, please.
Mr. N.K. Das. N.K. Das.
N.K. Das. Mr. N.K. Das for respondent number 4, Deputy Commissioner, Kamrup. The petitioner Maner Ali, alias Manser Ali, alias Manuruddin Sheikh, had been referred to the Foreigners Tribunal number 1, Kamrup Rural, resulting in registration of FT bracket stroke D 713 stroke 217 for rendering an opinion as to whether he is a person who entered the state of Assam from the specified territory subsequent to 25/3/1971. Full stop. The petitioner raises an issue that there was an earlier reference against him before the Foreigners Tribunal number 2, Kamrup Rural Boko, resulting in BFT case number 665/2016, wherein an opinion dated 14/7/2017 had been rendered that the petitioner is not a person who had entered the state of Assam from the specified territory subsequent to 25/3/1971. We have perused the opinion dated 14/7/2017 in BFT case number 665/2016. Full stop. A perusal of the said opinion makes it discernible that before the tribunal in the earlier proceeding, the petitioner had relied upon certain voters list of 1966, 1970, 1977, 1985, and 1989 to show that who is the father, that Khosul Sheikh of village Bipuria is his father. The tribunal, having accepted the materials available on record and having arrived at an opinion that the petitioner is a citizen of India, it is noticed that the earlier opinion dated 14/7/2017 in BFT 665/2016 by the Foreigners Tribunal number 2, Kamrup Rural, is a reasoned decision. Full stop. The principles of res judicata requires that the earlier decision must be between the same parties, and it must be a decision which, in other words, means a reasoned decision. Full stop. Heredity Kutub res judicata. The Supreme Court in, keep it blank for time being, had in its judgment, the Supreme Court in so-and-so versus so-and-so, reported so-and-so, had decided that the principles of res judicata are also applicable in respect of the proceedings before the Foreigners Tribunal. Considering the matter in its entirety, we are of the view that the subsequent reference made by the petitioner resulting in registration of case number FT/D713/2017 in the Foreigners Tribunal number 1, Kamrup Rural Kamrup, in respect to the petitioner, would not be maintainable under the law. Accordingly, the proceeding in case number so-and-so, as well as the opinion rendered therein dated so-and-so, are both set aside. And the petitioner shall now be governed by the opinion rendered by the Foreigners Tribunal number 2, Kamrup
1.
Rural Boko in BFT case number 665/2016, and would be subjected to all such entitlements under the law as he may be entitled.
How does high level?
Send back the eagles here.
Item 7 for orders.
Section 7. Yes, Mr. Khandakar. We close it. Heard Mr. M.R. Khandakar, Land Counsel for the petitioner, also heard Mr. B. Bhagavati, Land Counsel for the Mr. M. Bhagavati, Land Counsel for the respondent contemners. This contempt petition is instituted alleging willful and deliberate violation of the order dated. Where is the order, Mr. Khandakar?
Order page 11.
Page 11.
12 is the
What the order dated?
page 12. 5.
Dated 5/5/2022 in WPC 2370/2017, wherein there is a direction to the respondents therein.
Page 31.
31.
Page 31.
Therein to pay a compensation amounting to rupees 6 lakhs in favor of the petitioner. Full stop. In course of the proceeding, Mr. M. Bhagavati, learned counsel for the respondent containers, have produced a communication dated 4/3/2023 from the Assistant Inspector General Police bracket A, Assam, Guwahati, wherein it is provided that a check bearing number 000363 dated 3/3/2023 for an amount of rupees 6,00,000 had been issued in favor of the Registrar General Guwahati High Court in compliance of the Agor order to DDO, order dated so and so in WBC so and so. In view of the above, no further adjudication required. Contempt petition stands closed. A communication dated 4/3/2023 kept on record.
I'm on this.
Yes. In view of the order, I stand closed.
Item 8 and 9 for hearing.
That 1994 matter. Yes,
Ken Chaudhary is in court number 4, my lord.
sorry.
Mr. Ken Chaudhary is
No, let us hear the, we're hearing the respondents, I think. Let's
today
continue.
for the compensation part, my lord.
Yes, Madam Gayan, what is your view? You contest the matter or you agree to some compensation and close it?
Yes, no, last time, Honorable Court directed the petitioner to take instruction whether they are ready to take compensation or not, my lord.
Whether any compensation has been paid or not.
No, whether they are ready to take any compensation or they are going to, they are.
No. The requirement was for the respondents to provide us
Yes.
whether you are agreeable to close the matter by paying compensation or you want to contest that this kind of incidents never took place. It's up to you.
Yes, ma'am.
You are Kudus. See, Connor,
Yes.
there are two ways out. It's a matter 30 years old by now. One, if the persons were killed in a manner not contemplated by law, it may end result may be paying some compensation. So now, whether we go into the issue, whether the killing was absolutely as per law, permissible in law, or it was in a manner otherwise. If we decide, then the consequences may also follow. If the killing was in a manner other than provided by law, maybe you'll have to go a little further. As 30 years have gone by, instead of now again requiring us to decide the issue, if you are agreeable to pay the other consequence, that normally this is the compensation paid by the courts, then we close the matter. It's up to you.
May I submit, my lord? This is, as my lord said, it's a very old matter, my lord. We would also not like to go into the merits of the case, my lord. Our only administrative difficulty is that a case of compensation, the competent authority is the Raksha Mantri, my lord.
Sorry,
So,
Raksha Mantri.
Yes. So, my lord, that is one way to look at it. The other is we are agreeable with what my lord is saying and without going into the merits of the case.
No, we issue a direction to the respondents as a whole.
Yes, my lord.
Not just to the
Yes, Lord.
one respondent army authority,
Yes.
one respondent some other
Yes.
authority.
Yes.
And we follow the principle that around the year 1994, there were, yes, Mr. Chaudhary, you want to take a different view?
No, Lordship. Lordship, in fact, the Lordship was on, I did not get the first part. Lordship was on compensation on the earlier date, Lordship. In this line, Lordship, I have appeared in 3 cases, which I have forwarded, Lordship, the amount of compensation. Lordship, the guiding principles have been laid down in the case of Kanto Varisa by this.
In case of?
Kanto Varisa versus the Union of India.
Hmm.
It has taken into account all the previous cases of the Supreme Court and the Honorable High Court. In that particular case, taking into the facts and circumstances, the court has awarded a compensation of 20 lakhs each in Kanto Varisa.
20 lakhs each. And this is a decision of which year?
This is last year.
last year.
Last year. Lordship.
See, Madam Varman,
Ah.
if we follow this judgment,
And
then this is a decision as on today. We don't go for any interest, etc. Because this 20 lakhs determination is not with relevance to the year 1994.
My lord.
So either we take a determination of compensation in the year 1994 and then add the interest as it is now being paid in 2023, or we follow the determination on the quantification of last year and allow it without interest. Which one you prefer?
Recent decision.
And there are no, Lordship will kindly look into the facts and circumstances because in other two cases, one of Ratanjit Narjari and one of Wahagi Chutia, those are later in time than Konto Varisa. In Ratanjit Narjari Lordship, the court has given a compensation of 2 lakhs each. While in the Wahagi Chutia's case, it was 4 lakhs each.
No, which one we follow?
Here, no, Lordship, but the guiding principles have been laid down in the case of Konto Varisa Lordship.
In case of,
Konto Varisa Lordship.
Acha, this is a judgment of Guwahati High Court,
Yes, yes,
Bahagi Chutia.
yes, the three decisions are of Guwahati High Court Lordship. 3 cases I have appeared Lordship.
Understand. So what was awarded in Bahagi Chutia?
Wahagi Chutia Lordship, 4 lakhs each.
4 lakhs each.
Because
But
they were
4
found to
lakhs,
be, they were found to be Lordship.
no, 4 lakhs compensation was in vogue around 1993-94. There are a number of judgments of this court
That
on
is-
that quantification.
That is why I have also given Lordship the judgment
So
of
if
Konto Varisa.
we take the compensation quantified in the year 1994, then awarding it in 2023, it will require payment of interest of all these years. And ultimately, both amounts may be same because it's a matter of 30 years. When it is 30 years, almost 10 years, the amount gets doubled up. So
Yes, perhaps Lordship will follow Konto Varisa because Lordship, I find Lordship is far more
after all,
detailed
these are widows before the court, I believe, and their husbands were killed. And it's not that they were not killed. Only aspect is whether they were killed in a genuine encounter or it was killed in a manner a little otherwise here and there. For 30 years, no one could determine. And there is a report by the CBI which
That is
shows
against-
that they were
That is-
killed in a manner other than genuine encounter. There are some further materials. Only thing, there is a denial by the army authorities. So
Lordship may perhaps like to follow Konto Varisa Lordship.
20, good enough.
In fact, my lord, Leelabati Behera's case, the principle has been laid down. My lord.
Mr. Chaudhary, why you again open it up when it is
No,
already
I'm
closed?
just indicating, my lord.
But
The
that has
principle
also-
has been laid down in Leelabati Behera.
That has also been taken into account.
This Supreme Court taken everything into account.
Yes,
and,
yes,
then-
it will later judge.
So we follow that.
Only. My lord, the one thing is, my lord, the victim's family will get the compensation is well and good, my lord. Perhaps that is legitimately due to them. But my lord, the manner in which the army authorities function, that is also something,
Then we do a complete hearing.
my lord.
Then we'll go for a complete hearing. We also have to take the stand of the armies that they were done it in a legitimate
No, my lord,
manner.
what we are saying is, my lord, there was already a court martial proceeding. In that court martial proceeding, they were found to be guilty, not only CBI. Now, it is the appellate proceeding wherein, my lord, the order,
So there is no appeal against the court martial proceeding.
there is an appeal
In which one?
by the authority, my lord. In that appellate authority only, that order has been
No,
passed.
that will provide, that will be brought to its logical end. Whoever is done in whatever manner.
No, my lord.
We
there
are not opening a court martial proceeding in a writ petition.
No. What, there are 2-3 aspects. Sir. Of course, this is I had the instruction from my client, that's why I'm making this submission, my lord. In fact, I'm acting as sorry, my lord. I'm really proud. I was requested, that's why I'm doing it. Now, the issue is, my lord, yes, certainly, my lord, monetary compensation has to be given because there is violation of fundamental right. At least more particularly, right under Article 21. But there is also an aspect called accountability, my lord. Merely because.
Okay, then we hear you. We don't pay compensation now. We'll hear the complete matter. We'll hear it may go either direction.
Huh? Compensation.
It
Okay,
may
my
go
lord.
then it may go the either direction. We don't know. Here, considering it's a 30-year-old matter, we are trying to bring an end to it. But if you still want
Well,
to make it a live
My
issue,
client says, okay, they are agreeable to compensation. But I as Ken Chaudhary, I cannot agree to that, but I am bound by the instruction. my lord.
I don't know. Please
I
make
as
a,
Ken Chaudhary, I'll never agree to this. But since my lord, my
Chaudhary,
instructing council is
Mr.
saying that
Chaudhary,
they pay compensation,
understand,
I'm also agreeable.
understand. Make one submission. Make one submission. Either we do a complete hearing or we bring it.
No, my lord, the instructing council says they are satisfied with the compensation part, so.
Well, ultimately, we'll have to order a judicial inquiry now, if we have to go into that, so that everything can be taken. If you want, we can do it.
No, they are saying they are happy with the compensation, my lord. I can't say anything else. At least some succor they will get, my lord.
Why is it pending for 30 years now?
No, it was pending because, my lord, the matter was taken to Supreme Court also, na?
No, what happens is to make these inquiries, it is always better. It is if it is at a closer proximity with the date when the event took place. Then you have lot of evidence, lot of materials to either conclude
By
this way or
influx
that
of
way.
time, sometimes, my lord, it
Yeah.
is difficult to go into the.
So even if you order a judicial inquiry,
This state lordship,
even the army person who may have done this act, in the meantime, in 30 years, you don't know where they are also. You have to bring them to the dock in an inquiry. They also have to be cross-examined. They have to
Must
be,
have retired.
they
Most
have
of
to
them will
be
retire.
given an opportunity to present their case also. Straight away, we can't
No.
conclude either this way
No,
or that
it is-
way.
That is true, my
So
lord.
this
That
is-
procedural part has to be there.
Everything has to be done. But if you insist, we are still ready to do.
Then, my lord, since my instruct council says so,
Okay.
I don't have my independent voice.
Okay.
May it please the lordship, in item number 8,
Sorry, Mr. Mohanta.
in item number 8, the petitioner is because of the death of his brother, Pradeep Dutta. The Pradeep Dutta also included in the item number 9 also. His name is also there. right?
Please come a little this side. Please come a little this side.
My lord.
In item number 9,
Item number 8.
Eight.
Habeas corpus, petition 16. In that case, the petitioner was the brother, elder brother of the victim.
the
And-
person who died, his
Yes.
elder brother is
He is the petitioner here.
petitioner in item number 8.
Yes. In
Okay.
18 number 9, 5 persons have been, 5 victims have been mentioned, and one is the brother of this, the victim of the item.
So there will be one compensation.
Yes,
Now, who is to be paid? The brother?
yes, elder.
Or we prefer that the compensation should go to the widow, if any.
No,
First.
she died,
Secondly, widow,
died.
widow also died in the meantime. Any
And
children?
lordship will also take
No,
care
no children.
that the compensation money really goes to the person who needs
That's
it.
what I am thinking.
Maybe the respected district judge may be given the responsibility of.
So who
apportioning-
should be paid?
Apportioning
It's
the
not,
money.
it won't be bad because over the years, you don't know what is the
Yes,
situation.
we also don't know, my lord. So that money doesn't
Because
land up in
we
wrong
feel
hands.
the first one preference should be the widow,
Yes.
if any.
I think that
Second-
lordship can direct the district judge in Sukia to.
Second, children,
Ah.
then parents, then the question of brother, sister comes.
In my case, the widow died, no issue. Then father died, father of the petitioner died, the mother died, everybody died.
Lordship, let that be inquired with the district judge, Lordship. Who has to be paid, Lordship?
We do one thing, after determining the compensation payable, we place it before the concerned district judge. District judge will issue notice to the respective petitioner.
Yes.
And ascertain who is the best person to receive the compensation.
Yes.
It will be done within a period of 1 month, and thereafter,
It will be governed by the personal law,
and
my lord.
the amount may be deposited before the registry.
Yes,
So whosoever is determined to be the person eligible to receive the, he can.
They will receive. Because
can-
we also can't say, my lord, who is ingenuine.
He can withdraw the money from the registry.
Yes.
Lordship, one small prayer, Lordship.
Sorry.
One small prayer, Lordship, it may not be recorded as my consent, Lordship.
So we see.
Lordship will.
My lord, in fact, we have filed one affidavit indicating who all are there. That was filed on, my lord, 28/20 May 2022.
So the district judge will take note
Take
of
note
that
of this.
affidavit also.
Yes. It will be. This is it. কিবা এটা বাজি আছে নেকি? গ'ল। দিয়া হলে
Where is that CBI report?
my lord,
CBI report.
CBI report was আমাক তো দিয়া নাই না দিছিল। আমি ফাইল ফটো রেকর্ড দিব লাগে। মোক CBI report তো দিয়া নাই যে। এইটো হ্যাঁ report নহয় কিবা একসাথে দিয়ে annex কৰি দিয়া আছে কোনটো কেছত দিছে I think it is in the court's record, my lord. মোৰ তাত কিন্তু CBI report মই পোৱা নাই।
Inquiry report of the CBI. And where is the stand of the army authorities, Garhwal Rifles? I think of late, the army authorities also filed an affidavit denying.
No, their affidavit is regarding, my lord, disclosure of the information, not on this. The recent affidavit where they annex a letter of the Under Secretary of the Government of India, where they get.
Regarding that, giving of the records of the court martial,
That is
etc.
only to that. Yeah.
Where is that affidavit?
That affidavit.
That's
Yes,
the army.
that is there. That is, my lord, dated 28/11/22.
20.
No. Sorry, no. Wait, wait a minute. 28/11/22, my lord.
Nice record of record.
It is filed by one Major Shailesh Nair.
एक मिनट.
CBI. My lord, there were 10 detainees, my lord. 5 were killed, 5 were alive. In camera, they have given a statement which is in the court record. Under seal cover, it has been retained by the registry, my lord. There were 10 boys.
Understand? Should he go into it?
No, I'm just indicating, my lord.
No,
That is there in seal cover.
moment we go into it, it will require again one more inquiry. Up to you. If you want an inquiry, we can,
Well,
but it will take,
normally-
I don't know what will be the ultimate outcome of that inquiry
Right.
after 30 years. So you take your call.
No, my lord, I'm going by my instructing
See,
counsel
if
that,
we go by that, we are not going into any of the issues.
yes.
We just take note of the materials on record, the general denial of the army authorities, that there is also a court martial, and without arriving at any conclusion as to whether the army authorities are culpable or not, as the death had taken place
During the-
in a case, we are awarding compensation and
During
it
their
closes this
custody.
matter.
That has occurred because
Huh.
during their custody.
That is precisely.
No. No, little short of that.
That is.
And if
precisely
you
what
want,
was
we can go
accepted of
into
the
it.
person.
Take your call. Because repeatedly you are having the tendency to go into it. You take your call.
No, I have taken my call.
Huh.
I cannot take my individual call.
So
I'm going by the call of. my
we
instructor.
can't go halfway.
Yes.
Either we don't go at all or we go complete. Get into the root of the entire thing. If that is so, maybe our orders will be also take appropriate action also. But before that, it has to be conclusively established by following the due procedure of law.
Anyway, my lord, factually, I'm not making any legal submission. Factually, even court martial found them guilty. Not only CBI charged him.
Court martial, we leave it to them to bring it to logical, whatever they want to do it. Heard Mr. K. Chaudhary, Learned Senior Counsel for the petitioner. Also heard.
It's coming.
I think Lordship has got that report of the CBI, my lord. It is on record.
You were originally Also heard Mr. R.K.D. Chaudhary, learned DYSGI, for the respondents in the Union of India, including the army authorities. You were a guy, and you were there, or Mr. Chaudhary is there?
Yes.
She is there.
No, my lord, his name may be
No.
like.
She, Lordship may record her name, Lordship. She has
You-
been there.
You decide between you.
My lord, accepted maybe, maybe.
Okay, there are two writ petitions.
No, my lord. that may
There
be
are two
recorded.
writ petitions. We're reading one Mr. Chaudhary, one.
No,
And
it is-
as well as MSU DAS, Learn Council for the respondents in the state of Assam.
And my London friend for CBI.
CBI is not a respondent. No, are you a respondent? Then we don't have to hear you. We'll take note of your report. When we appreciate your services. এই দুখন ৰিট আছে নহয়, এখন তেখেতক দিব, এখন দিব। এইকাৰণে call your name, please.
Colonel Mahesh Sharma. Colonel Mahesh Sharma.
Colonel Mahesh Sharma, Deputy
Deputy Judge Advocate.
Judge Advocate General for the Army Authorities, is also present in the hearing. Although the CBI is not a respondent in these proceedings, but there was a requirement. But during the course of the proceeding, there was a requirement for the CBI to make an inquiry and submitted a report. And accordingly, a report is made available on record by means of an affidavit dated 10/3/1998. And Mr. Haloy appears for the authorities in the CBI. WPC, civil rule bracket habeas corpus 17/1994 had been instituted by Sri Jagadish Bhuya, the then Vice President of the All Assam Students Union, raising an allegation that 9 persons
Lordship's kind permission, can I take leave? My friend would be there.
that 9 persons, namely Probeen Sonowal, advisor of the Tinsukia District Students Union, then aged about 24 years, was arrested by the army authorities from his residence at Dumduma on 17/2/1994. People were sentenced to put begin coercion. It is semicolon here. Akhil Sonowal, who was an employee of Khoang Tea Estate under Talab Police Station, was arrested by the army authorities on 17/2/1994 while he was discharging his duties in his office, semicolon. Devajit Biswas, aged about 23 years, who was a student and was arrested from his home at Dumduma on 17/2/1994, semicolon. Gunin Hazarika, aged 22 years, who was a student and was arrested on 19/2/1994 from his home at Dumduma, semicolon. Pradeep Datta was arrested on 18/2/1994 from his home at Talab, Dumduma, semicolon. Manoranjan Das was arrested on 18/2/1994 from his home at Dumduma, semicolon. Bhupen Moran was arrested on 17/2/1994 from his home at Dumduma, semicolon. Prakash Sharma was arrested on 18/2/1994 from his home, from his house Diva, at Dumduma, and Morestor Moran was arrested on 19/2/1994 from his house at Dumduma. The petitioner raised the assertion that except for Okhil Sonowal, all others persons who were arrested were members of the All Assam Students Union. In paragraph 4 of Civil Rule Habeas Corpus 17/1994, it is stated that all the persons were arrested by the army authorities on between 17/2/1994 and 19/2/1994, and till the filing of the writ petition, their whereabouts were not known, and neither the army authorities had informed their families about the grounds of the arrest. WP Civil Rule Habeas Corpus 16/1994 had been instituted by Sri Deepak Kumar Datta in respect of Bhupesh Datta is included in the earlier petition.
Pradeep Datta is included in the.
Acha, detainee is Pradeep Datta. Pradeep Datta, ki likhna? Sri Deepak Kumar Datta, raising the allegation that his brother Pradeep Kumar Datta had been arrested by the army authorities on 18/2/1994 from his house. We take note that the arrest of Pradeep Kumar Datta is also a subject matter included in E2, Civil Rule Habeas Corpus 17. Which document will show that for the first time it was informed that these people are no more? Because the petition started on the premises that they were arrested.
We have to solve.
Lordship, there is an order, Lordship. There is an order, my lord, 24/2/94,
24
294, passed by this honorable court. my lord.
294,
Yes, my lord.
in which,
Where my lord, my senior Pathak made a submission that this person is not killed.
no, it is in WPC 17.
There- Yes, 17,
17. Which order dated
24/2/94.
24 to 24 to 94. It's no, till 1/3/1994, somebody was produced before the court. The persons who are produced in the police escort before this court shall be taken back to the police escort.
This
So that means till,
from 9, my lord, 5 died and 4, my lord, arrived. Survived, my lord. These 4 persons are produced before this honorable.
okay, and they stated that these other 5% are no more.
And they are.
Can you record it?
Recorded in camera, my lord. And these are in before your lordship. And the seal of.
In course of the proceedings,
Out of 9.
comma, on 1/3/1994, four of the aforesaid 9 persons were produced before the court under police escort. And in the order dated 1/3/1994, certain statements made in course of a proceeding held by the learned district judge Tinsukia in camera was produced before the court, comma, which indicated that 5 of the aforesaid persons, namely, who all died?
My lord, Probin Sunwal,
Namely, Probin Sonwal,
Akhil Sunwal,
Akhil Sonwal,
Devojit Vishwas,
Devojit Biswas,
Pradeep Datta,
Pradeep Datta,
Bhaben Moran,
and
Bhaben Moran.
Bhaben Moran. Bhupen. And Bhaben or Bhupen? Just check up. Yeah, we Bhupen Moran, because in our earlier order we
Bhupen.
wrote as Bhupen. Bhupen Moran had died in the meantime. Other 4 are released in the meantime.
Released.
Uh,
They were released, my lord.
the other 4 are released. The 4 others who were also arrested in the same incident, in course of the same proceeding, namely, give the names of the other 4. They have in the meantime been released. Namely, Baki Sarita have in the meantime been released. In the circumstance, these two writ petitions, habeas corpus writ petitions, survives for an adjudication in respect of the death that may have been caused in respect of sorry, the past number, these 5 names. Full stop. In course of the proceedings, an inquiry was also conducted by the CBI, and an inquiry report dated 7/3/1997 of the CBI has been placed on record by means of an affidavit. This is an affidavit in opposition by the army authorities against a CBI report. Where is the CBI report?
CBI report is here, my lord. I have been served a copy. Separately, I have been served by a copy.
We take note that the CBI had conducted an inquiry pursuant to the orders dated 10/3/1995 and 31/7/2000 of this court in respect of the present proceedings. CBI report dated so- CBI report dated 6/2/2002, not 1997. Paragraph 2.21 of the report of the CBI dated 6/2/2002 2.21, 2.22 are extracted as below. A reading of the contents of paragraph 2.21 of the CBI report dated 6/2/2002 makes it discernible that the CBI had arrived at its conclusion that it is disbelievable that the injuries that were found on the deceased persons were because of any encounter. And accordingly, the CBI held that 5 army personnel, namely, repeat Kori, 1CC so and so, Captain Shivarani of so and so, so and so, so and so, are responsible for killing of the 5 persons namely those 5 dead persons, as they had actually opened fire on them and therefore liable to be prosecuted under section 302 stroke 201 of the Indian Penal Code. The CBI report also arrived at its conclusion that 2 other army personnel, namely IC 2071 Colonel A.K. Lal, commanding officer of the 18th Battalion Punjab Regiment, and Major Thomas Matthew of 18th Battalion Punjab Regiment, are liable to be prosecuted under, or are also liable to be prosecuted under section 302 stroke 30201, read with section 109 of the Indian Penal Code, as because Colonel A.K. Lal had planned the entire operation and Major Thomas Matthew was leading the party and had ordered the firing. Paragraph 2.2 of the report of the CBI dated so and so makes it discernible that charge sheets against the aforesaid army personnel were being filed in the court of the Special Judicial Magistrate Kamrup Guwahati with a request to forward the charge sheet to the army authorities to try the accused persons under the law of court martial as per the provisions of section 70 of the Army Act 1950. An additional affidavit in opposition filed by the respondent army authorities what happened in the court martial?
My lord, in the court martial, my lord, first, the findings was that the accused.
Can you have that records
Yes, my lord, please.
so that we can record it in order?
My lord, these were two sealed envelopes, my lord, in which the court.
No, we
my lord, what
don't
only the
want it in
relevant
that form. Give us the
finding.
findings.
Yes.
The number of the case number of the court martial proceedings and the finding thereof, and in appeal what had happened.
My lord, may I just give a introduction of what it is, my lord? My lord, in the court martial, there was no appeal. The court martial, originally the accused were found guilty. Every court martial proceeding is required to be confirmed. And
In confirmation, some other view was taken.
yes, in confirmation, the court martial proceedings were remanded back to the same court.
For a reconsideration.
For reconsideration, because there are certain evidences which. were not
Understand.
sustained.
Now as of now, it remained at that stage.
No, my lord. After that.
Ultimately, what happened? What's the final
Ultimately,
conclusion?
They were found not guilty, and that has been confirmed. What my lord has is the final finding of the court. I have flagged it and put it before my. This one. The yellow flag. There's a copy of that. Receipt.
No, this signed on 1/3/2020 is the first order,
My lord, this is the final finding.
not the final. Give us
The confirmation, my lord, of the
no,
final finding.
give us the first order, the original order, then the confirmation order, then the
Yes.
final order.
My lord, so I've got these flag. It has got the first order, then the revision order, and in like.
You can hand over. Yeah.
There are two copies.
In the order of the court martial proceedings, corresponding to file number. To number 2. I think can you give a photocopy of this page?
My lord, Sita for my lord.
Okay, you can retain it.
Yes.
Okay. Case number 2 Silabo, huh? This is the first one, confirmation place. In case number so and so. Keep over sentence 2. To file a so and so. In the confirmation minute. What was held?
Yes. Lord.
No, this doesn't contain anything. It says summary court martial in respect of so and so, so and so, so and so, so and so. All the names are there. All attached to headquarters. But what kind of an order was passed?
Lord, the final order which was passed.
Not the final, the first order.
The first order which was passed was that they were found guilty.
Where is that?
Lord, that is, they approach my lord and show.
You wait.
My lord has the first paragraph of the finding, which is page number 26.
26. Okay.
340.
Okay.
The first paragraph says that guilty of the person in the act of.
Corresponding to file number 4. No, in the confirmation window. What is the date of this order?
My lord, the date is mentioned there. It is, I'll fill that, my lord. Because the copy is with my lord, I'll fill that and give it to the court master.
Is it 13/10/2018?
Yes,
In the order dated. So it's dated 13/10/2018, comma, the court found the accused Colonel R.K. Shivrain, comma, Sri Dalip Singh, comma, Subedar Major give the names in a piece of paper. I think it will be easier for us because here all kind of things are written here.
yes, I'll do that.
Then so and so. Are guilty of the first charge. That is, first charge is section 302.
302.
That is under section 302 of the Indian Penal Code. That is the only finding.
Yes, Lord.
And,
They found guilty.
and there's no other finding.
There is a detailed brief of the.
No,
reason.
reasons are there, but
Yes.
finding is only one.
Yes,
Full stop. As there is a requirement under the Army Act what's now? (1950)
yes, Lord.
to have the conclusions of a court-martial court to be confirmed by the
Yes,
by whom?
by the competent authority, my lord.
By the competent authority, the proceedings of the court-martial in respect of the aforesaid office army personnel
Yes.
were also placed before the competent authority. The competent authority by its order dated
My lord. I'll give the date, my lord. I'll give that date. It's there in the order. I'll fill it up
Okay,
with the
dated
court
so and so, had they sent the matter back to the court martial authorities
for revision
for a revision of their earlier decision
in terms of Army Act Section 160.
in terms of Army Act
Section 160.
164,
Yes. 160. 160.
160. And what do you, in revision, what was done?
My lord, in the revision, additional evidence was taken and they were found finally not guilty.
In the revision, the court martial authorities took some further evidence and accordingly by the order dated, which order?
My lord, that order of the revision again.
Order dated so and so, found the army personnel to be not guilty of the charges. Into revision order 5/11/2019. In the aforesaid factual situation, the two habeas corpus writ petitions are taken up for its final hearing. On one hand, the petitioners urge upon the report of the CBI dated 6/2/2002 to establish that the aforesaid 5 persons, namely so and so, were killed in the custody of the army authorities, and death was caused to them in a manner other than a manner acceptable in law. Whereas, on the other hand, it is the stand of the army authorities that in furtherance of the report of the CBI inquiry, the court martial proceedings were held as per law, and which resulted in the order in revision dated so and so, wherein all the army personnel were found to be not guilty of their charges. Without going into a further inquiry, maybe in the form of a judicial inquiry, to establish the fact as to whether the death was caused to the whether the death caused to a pastanam, were in a manner unacceptable in law or otherwise. What's the sentence? The materials available before the court at the present stage would be that a report of the CBI inquiry indicates towards the death having caused in a manner other than acceptable in law, whereas the final conclusions of the army authorities is that the death was caused in a manner acceptable in law, meaning thereby that the army personnel are not guilty of their charges. We have also taken note of that this writ petition is pending since the year 1994, and 29 years have already passed by. Submissions are also made from the respondents that if at this stage a judicial inquiry is ordered, due to lapse of time of almost 29 years, the army personnel who are alleged to have been involved of causing death to the 5 persons, namely so and so, in a manner other than law, would be seriously prejudiced to defend their cases, and full stop. A stand is also taken that the 7 army personnel who were indicted in the CBI report have already successfully defended themselves in the court-martial proceeding, which proceeding was initiated in furtherance of the report of the CBI, where the CBI had also filed their charge sheets. Can you prove it? Can you prove your case now?
Means
No,
that
they
evidence-
say they have difficulty. Do you have witnesses to establish that they are guilty?
Yes, we appear before the court martial. The persons are allowed to appear before the court.
Which person?
My lord, family members. They-
No,
they
no,
are-
no. Do you have any material to establish?
At present, I do not know whether they have material. or
No,
not.
suppose we order a judicial inquiry. Do you have
Yes,
any
yes,
material
yes.
to establish?
Their family members are still there. They
No,
will
no, other than your allegation, do we have any material to?
take hearing. This is-
Huh?
The persons died. This is the admitted position.
No, person may die in any circumstance.
And CBI report is there.
CBI report has already led to this one.
CBI report is there and police and.
Madam Bormon, CBI report had resulted in filing of charge sheet.
Yes, district.
When-
judge Tinsukia-
Just- Just a minute. When charge sheet is submitted against the army authorities, the Army Tax Act takes over. Resulted in the court martial. Court martial ended in this particular conclusion. So CBI report has no further relevance. What we are asking you is, do you have any credible material with you that if we order a judicial inquiry, you will be able to prove your case?
My lord, one thing is there, the district judge Tinsukia was directed to collect all the relevant documents. That is also.
We are
there,
not
my
on the past history, we are on the present.
lord. At present, there is no such.
Can you prove it?
At present, no, my lord.
If you cannot prove, it will be a futile exercise. That is what we are trying to ask you. And if you have say that, no, we have absolute credible materials, maybe we can think of it.
Accept the family statements of the. family
Other than
members.
statements, you have to
I don't think such
Hmm.
things are there now.
full stop.
So we enter to review the-
We have also inquired from the learned counsel for the petitioner as to whether the petitioners still have any credible materials with them to prove it beyond reasonable doubt that the death to the aforesaid 5 persons were caused by the army authorities in a manner other than the manner acceptable in law. It is fairly stated that as of now, no such materials will be available. Considering the rival submissions regarding the futility of ordering a judicial inquiry, that is the stand of the petitioners that no further credible material may be available,
that way-
but the other consequences, we are withdrawing this order, then we'll allow you, but if you fail,
My lord,
it will be
all right.
and credible material is not that the man died,
Fine.
that the death was caused by them in a manner unacceptable in law. কি করলো? Materials may be available, not available, may be available to establish. And also the stand of the army authorities that because of the elapse of time, the army personnel are they still in service,
Most of them have retired.
where most of them have retired from service, may not be in an appropriate situation to defend themselves. কি করবো, by the beginning of the sentence. Comma, we are of the view that instead of trying to arrive at a definite conclusion as to whether the death was caused in a manner other than accepting law, we accept the situation that the death of the aforesaid 5 persons, namely so and so, took place while they were in the custody of the army authorities.
They
Or
were-
where the death took place then.
Was not in the custody, it was while in the operation, Lordship.
That took place during an army operation.
They were in custody, my lord.
Ah.
They were taken from home and the respective houses,
That
and they
is,
were with the army.
that we have of course denied, Lordship.
Did you arrest them? No.
No, not arrested.
Where is your operation? Full stop. Keep it, end it here only.
My lord, public issue, my lord, lots people are, my lord.
Okay, withdraw. We'll hear you. Withdraw the order. We'll hear you complete. Yes. Argue.
My lord,
Start from the beginning.
Postmortem reports are there, my lord, and
Stop.
for that, my lord.
Start from the beginning. Yes.
my lord,
Argue. We'll hear you.
It may complete it today.
No, then nothing. No, we'll go to the root of the matter. We'll till you can decide. We'll order a judicial inquiry. If the judicial inquiry results in any,
My lord, the CBI inquiry is enough to prove it, my lord.
My lord, lordship, as
It
your
is
lordship.
clearly mentioned,
All
my
right,
lord.
as your
It
lordship.
is clearly mentioned.
okay, you argue.
My lord, it may be hard today itself.
No, it will
and
not-
No, that's why I said,
Yes.
please start your hearing. It order record this for.
Completed, my lord. It is in the right, it is in the right direction, my lord. So
Lordship may complete, I am sorry.
That's why I told you in the beginning, take one stand. Don't take divergent stance.
No,
You can't take two stands. You have to take one stand. If you are in a position to make a definite statement that we can prove, we'll order a judicial inquiry. And the result of the judicial inquiry will be brought to its logical end. If you cannot, let us end it here.
my lord, lordship, as your lordship.
Then the other part of penalizing the army personnel will not be there, but compensation payment will be
yes, my
there.
lord, the compensation that will do, my lord. Your lordship may pass accordingly.
I'm sorry, lordship.
No, sir, we have to give reasons for our audience.
Yes.
And we can't be oscillating between two ends. We have to be firm in whatever we say. We take only one stand. কি বলবো? In an army operation, without arriving at any conclusion as to whether that was caused in a manner acceptable in law or in a manner unacceptable in law. But however, as it is an admitted position, however, as the materials on record clearly indicate that the death had been caused in an army operation where it cannot be, where the materials available on record cannot lead to a definite conclusion as to whether the death was caused in a manner acceptable in law or unacceptable in law, comma, for the interest of justice, we order the respondents in the Union of India through the army authorities to pay an adequate amount of compensation to the families of the 5 deceased persons. In this respect, we take note of just a minute. We take note of judgment rendered by this court on 25/3/2022 in WBC 4368/2014, reported in 2022 3 GLT 187, as well as 2022 GLT, wherein in a similar circumstance, where death was caused to certain persons in an army operation, comma, it was deemed appropriate that an amount of compensation amounting to rupees, where is that 20 lakhs? Amount to rupees,
Lordship, paragraph 113. That is 40 lakhs. 40 lakhs, 2020 each. That- Paragraph 113. Lordship.
head note. Head note, my head. Data say, percentage, the onward superior, having decided the 47. 47. কি বলবো? Rupees 20 lakhs be paid to the families of each of the deceased persons. Without taking the matter any further, we accordingly direct the respondents in the Union of India through the army authorities to pay an amount of rupees 20 lakhs as compensation to the family members of each of the aforesaid deceased persons, namely so and so, so and so, so and so. As over the years, a question would remain as to who would be entitled to the compensation on behalf, in respect of the 5 deceased persons. We placed the matter before the learned district judge Tinsukia for issuing notices to the families of the 5 deceased persons and ascertain as to who amongst them would be most entitled to receive the compensation amount. The army authorities are respondents directed to pay the amount of rupees 20 lakhs each to the 5 deceased persons before the registry of this court within a period of 1 month from today.
May I pray 2 months, Lordship?
2 months from today. In the meantime, the pursuant to this order, the respective claimants of the family members of the 5 deceased person to appear before the learned district judge Tinsukia for the adjudication as to who would be the most suitable person to receive the entitlement within a period of 15 days from today. Upon their appearance, the learned district judge is requested to arrive at a determination as to the best entitled person to receive the compensation within a period of 1 month from the date of their respective appearance. Stop. As per the decision that may be taken by the learned district judge, the person who is declared to be the best person entitled to receive the compensation may receive the compensation from the registry of the court after 2 months from today.
My lord, in that case, my lord, the persons who approach the district judge, whether then someone will be issued to them?
No, they will notice.
No, they will themselves appear. In determining as to who would be the best person, the district judge, as per its wisdom, may issue notice to any other person who, according to the learned district judge, may also be entitled and accordingly take the decision. Suppose X goes, district judge feels that Y may also, he will issue notice to Y also and determine who between that will get.
Master.
The two petitions are closed as by providing as indicated.
That's okay.
A copy of this order may also be transmitted to the learned district judge Tinsukia for doing the needful. Will the writ petition records should also be sent? I think it is not required.
So order is sufficient.
If records are not sent, then.
My lord, we have filed the affidavit regarding the survivals of the dead person, my lord. Next to the kin, my lord, that may consider.
The affidavit filed by the petitioners regarding the surviving next of kin of the deceased person be also taken note of by the learned district judge in arriving.
My lord, in my affidavit, one name is wrong. I may be allowed.
You can correct that.
Right.
No, we are asking, will these records be required? I don't think it is required.
Records not required.
Are you? That affidavit will do. If the learned district judge is of the view that to arrive at his proper conclusions, the record of the present proceedings would also be necessary. Accordingly, a photocopy of the records may be requisitioned from the registry.
Item 10,
No, in the other matter. In the other matter that we just dealt with. Where is the counsel for the petitioner gone? What we provide, Colonel, the proceedings in the court martial, which resulted in the order revision, will provide that by virtue of our order, if somebody wants to proceed against that, we are not foreclosing it. That we cannot do. If anybody wants to further proceed against these orders, this order will not foreclose that. That's one line we are adding. And under the law, we can't do it also. We cannot give a finality to a proceeding. Army Act. So if under the Army Act, some provision is available to anybody, we are not for Mr. Chaudhary. What you indicate is that the revision order in court martial, which presently is favored the army, by this order, we are not foreclosing the right of anybody to proceed against that. But we better clarify it also, because otherwise somebody may take the stand that because of this order, that has also come to an end. To that extent. So very good.
item 10,
Yes, Petitioner.
And I'm coming to here, immediately my lord, just find page 14. The type copy and the copy is not should find page 17. Is the deputy eligibility certificate from 1965. So by the authority of the camp is the name of Amultawala Ghosh, wife of Ravindra Chandra Ghosh, and also in the page 15, the name of the petitioner as a son, Professor Chandra Ghosh was mentioned. Because 14 years.
Mr. Nath, where is the order of reference?
Order of reference is possible fine. Page 44.
Page 44.
12/7/19. And the filing kind of was still fine.
No, this is the judgment of the tribunal. Where is the reference? Who is referred? Of village PS Lanka.
Yes, ma'am. Reference case number was still fine, 809. 16.
Any material to show that Srimati Amulya Bala Ghosh
Yes,
ultimately settled and resided at Lanka Hojai,
ma'am. Yes, ma'am.
because the reference is against Gopal Ghosh of Lanka,
Yes, ma'am.
whereas that relief eligibility certificate does not indicate where Amulyawala Ghosh resided.
Amulyawala Ghosh, my lord, because the petitioner has shifted to Lanka character. And in his name.
Mr. Nand, that's what we're asking. It's a statement. Any material to show?
No, my lord, it is his mother. Total list is, let's find page 23. Page 23. Amulyawala Ghosh is there, my lord.
What is
Amulyawala
page
Ghosh.
23?
And that is the Bhushan Ghosh. Title has been wrongly mentioned. Is in district Nagaon, region Nagaon, village ward number 2. It is not Lanka, not Lanka.
This is also not Lanka.
He was residing at Nagaon. And thereafter in Lanka, his mother has no potential. Because he himself is there in India in 1965.
Where is it?
Yes, ma'am.
65.
Find page, page 18.
Page 18.
18. Page 18. ma'am.
What is this?
Bhapesh Chandra Ghosh with his mother.
Page 18.
Page 18. ma'am.
Page 18 is some original handwritten copy.
Yes, madam, that is the original copy, and type copy I am showing, madam. Type copy and she will find.
Mr. Nath, we are satisfied that Amulyawala Ghosh had received a refugee eligibility certificate.
Yes, madam.
We are also satisfied that her son is Gopesh.
Special.
What we are asking you is Gopesh of Lanka and that Gopesh are the same person.
Special Lanka, my lord, I could show any document of his mother at Lanka. But
Do you have any further document to show, say, ration card, etc., of Lanka,
because at that time,
which would show the name of Amulyawala and Gopesh together? Produce that any such document if you have.
mother was expired at that thereafter, my lord.
Oh, maybe an old document also when she was alive. Ration card.
Ration card, my lord.
Ration card of Lanka. That's a very good document for you.
Yes, my lord, that I have to take instruction, but only he has also another citizenship certificate, you know, she. Just will find.
Citizenship certificate,
Yes, my lord, just one page 20.
page 20.
Corporation in the name of Gopesh Ghosh,
Hmm.
son of Govinda Ghosh. Page 20.
Sorry, just slow.
The additional deputy commissioner Naga.
Certificate of registration.
He has to register their name.
Gopesh Ghosh, son of Govinda Ghosh. Hmm. This is dated
Taken my lord,
79.
1979, I think.
send the land document in his name, my lord.
Village Hilasya. Relief eligibility, Amulyawala, Village Hilasya. Village Hilasya. Is from where migrating? Mr. Sharma, please take, come to page 17.
Yes, notes it.
Place from where migrating, village Hilasya.
Yes.
Clause 4 below.
Yes, yes.
Now you come to page 20. this Gopesh Ghosh, son of Govinda Ghosh, his place of birth is also village Hilashia.
Yes, Lordship.
So must be the same person.
Yes, Lordship.
So once it is the same person, he's also having a certificate of registration.
Yes.
So once he's having a certificate of registration under the Citizenship Act, he's a citizen.
Yes.
We can declare him to be a
Yes,
citizen, I think. It will go in some, everything is coming to the same. Heard Mr. S. Nath, learned counsel for the petitioner. Also heard MSL Devi for respondent number 1, Union of India, 6 NRC. Mr. G. Sharma for respondent number 2 and 4, authorities, Home Department, Government of Assam. MS M. Dotto, MS M. Dotto for respondent 3, Deputy Commissioner Hojai. And Mr. A. Ali for respondent 5, authorities, Election Commission of India. The petitioner Gopesh Chandra Ghosh, alias Gopal Ghosh, son of Govinda Chandra Ghosh, resident of Lanka Station Road, had been referred to the Foreigners Tribunal number 7, Hojai at Lanka, for rendering an opinion as to whether he is a person who entered the state of Assam from the specified territory subsequent to 25/3/1971, resulting in registration of FT-L- case number 809-2016. The petitioner relies upon a relief eligibility certificate issued by the Ministry of Rehabilitation, Government of India, dated, what's the date of page 17? Dated
1965.
dated 25/8/1965, which was issued to Srimati Amulya Bala Ghosh as the head of the family, showing her husband's name to be Govinda Chandra Ghosh, and further providing that she had migrated from village Hilashia, police station Bajitpur in the Maimansingh district of the present Bangladesh. The relief eligibility certificate also includes the name of Sri Gopesh Chandra Ghosh, showing him to be son of Srimati Amulya Bala Ghosh. The petitioner also relies upon a certificate of registration under section 5 bracket 1 bracket small a stroke bracket small d of the Citizenship Act 1955, bearing CC number 9/79, serial number 123435, issued by the Additional Deputy Commissioner Nagaon in favor of Gopesh Ghosh, son of Govinda Ghosh, whose date of birth is shown as village Hilashia in the Maimansingh district of Bangladesh. Full stop. Reading together the relief eligibility certificate dated 1965, which shows that Srimati Amulya Bala Ghosh had migrated from village Hilashia, police station Bajipur, district Maimansingh of Bangladesh, and the Citizen and the certificate of registration as citizen in favor of the proceedee Gopesh Ghosh, son of Govinda Ghosh, Govinda Bala Ghosh, wife of Govinda Ghosh, whose place of birth is shown to be village Hilasia in the Moimansingh district of Bangladesh, we are of the view that the petitioner is able to discharge the burden under Section 9 of the Foreigners Act 19. Foreigners Act, which year of the Foreigners Act?
1946.
1946, that he is a citizen of India. Accordingly, the petitioner is declared to be, is accepted to be, not declared, no, is accepted to be a citizen of India. And by further providing that being so, he will be entitled to all the rights and privileges as he may be entitled as a citizen of India. Petition allowed as indicated, send back the LCR.
Item 11.
9 discharge to India. Oh, I just requested you in the earlier case, by this order, we don't mean that the court-martial proceeding revision has ended. You'll be at liberty to proceed against that if you want so. Means we're not liberty, we say that but by virtue of this order that earlier proceedings is not closed. And either parties may bring it to its logical end if so advised. That has to be there.
My lord, it's only that it's my lord's wisdom, my lord, we bow down to that, my lord, because it's an old litigation and
No.
it should not start another cycle of.
Mr. Sharma,
yes,
we
ma'am.
cannot close something which is not before us.
Yes, ma'am. Yes, ma'am.
We are deciding it on another issue.
Yes, ma'am.
We have, no one is before us against that revision order.
Yes, ma'am.
So we cannot pass any order either this way or that way in
Yes,
that
ma'am.
proceeding. That we
Yes, ma'am.
will only indicate that this
creating-
order
yes.
will not indicate that that proceeding has also come to its end.
My lord, without creating any, I mean, I bow down, my lord, that's all, my lord.
If
My lord
somebody
knows what-
comes, you take your appropriate defense against that.
Yes, my lord, because it's already been a cycle, my lord.
We have already made those observations. Yes, next
Item 11.
My parents' names, lordship, kindly may have to pass 29 lordship.
Sorry.
Page 29 is the name of my parents.
Volume to comma here.
Oh, yes, lordship. Page 29 lordship.
Page 29.
Yes, lordship. My parents are there, lordship.
Who is this?
Zohur Mia is my father, lordship, and Rosana Khatun, my mother.
Page number?
29 lordship.
29.
Translated copy.
Zohur Mia is the father.
Father, yes. And Rosana Khatun, my mother.
Village Khudra
Kudra
Babun
Babun Boli.
Bori.
70 also, lordship.
Which material will show that you are the son of
Yes,
Zohur Mia?
lordship. I, lordship, submitted 3 documents, lordship. One Panchayat link certificate, one Gaura certificate, and my brother, elder brother also had them, lordship. My Panchayat certificate is my first, lordship, page 72, lordship. And the secretary was examined, lordship. Gaura also examined.
Just a minute, page
72.
What is the certificate?
This is lordship says, lordship.
Certified that so and so, daughter of the
Yeah.
Is aged about was a resident. And where is the evidence of the Gaumura?
Gaura's certificate is the next as an evidence, lordship. Declaration, lordship is this. Lordship,
No, this is certificate of the Panchayat.
Link certificate, Lordship. Thereafter, Lordship, the
No,
certificate
no,
of
no,
Gaura
this is Secretary Gaon Panchayat.
Yes, Lordship. And Gaura service is the next page, Lordship.
No, we understand it's a certificate. What is the, who had issued this certificate?
To Concert Secretary, Lordship, and countersigned by BDO, Lordship.
Yes. Mr. Sharma, your BDO, it's a government official. He certified that it is this.
Then I need to take instruction regarding these documents.
What instruction?
Lordship. On
He told you, it's already in record. Your own official has certified. Had it been only the secretary, we would have put some questions to Mr. Hawk.
on what basis and
But-
for what purpose, Lordship? It was?
We don't know. It is your officer. You go ask him. If it is brought by any other authority, a natural question flows is on what basis that person has issued this certificate. But once it is a government official, we don't have to put that question. You have to put that question. The petitioner relies upon a certificate dated 29/6/2015 issued by the Secretary number 15 Dokhin Pub Horukhetri Gaon Panchayat, by which it is certified that the petitioner Rup Bhanu Nesa, daughter of Zuhur Mia of Khudra Bamunbori village, got married to Julmat Ali, resident of number 1, what is it?
Larkushi.
Larkushi, under Mukalmua Revenue Circle. It is noticed that the said certificate is also counter-signatured by the BDO,
Circle officer.
by the circle officer. The respondents in the Home Department to submit a report as on the authenticity of the said certificate and whether it was countersigned by the circle officer, and if yes, what was the basis of the information of the circle officer to issue the list after a week.
The person was examined, Lordship. His report is
One list after one.
No, we are on the counter signature. If the counter signature is good, you are true.
Yes,
You don't have to bring any more evidence.
Lord. Hello, sir.
Item 12 for orders.
Yes, Mr. Nath.
This is the IA is for regarding my lord. Earlier order was passed by this court directing the petitioner to appear now before the SP.
For releasing the petitioner from detention.
Yes, madam, but it is mentioned also in the writ petition that he was arrested on the date of judgment, and that was not, my lord, mentioned in the earlier order. So now petitioner is given your lordship by this IA to direct the since.
Yes, Mr. Sharma.
Yes.
That usual interim order, I think he is also entitled.
Yes, Lordship. No.
He is a hereditary. Heard Mr. S. Nath here, no? It is normal to have to release order be given. Heard Mr. S. Nath and counsel of petitioner also heard. Number being agreed by the opinion No, no. Where is the earlier order of the court, Mr. Nath?
Earlier order, your lordship will find that
Uh,
page
Please.
in the IMS.
Ah,
IA.
you are already released. A petitioner shall appear in the meeting if the petitioner has not yet been detained on the strength of the person shall not be taken and reported.
Now, if the petitioner not
However,
yet
shall
taken-
appear who may operate on such a shall furnish. Okay, if the petitioner had not been detained, that is provided, but
Yes,
actually
yes.
you were detained even prior to that.
Yes, ma'am.
Yes.
কি করলো, the petitioner? Where is the opinion?
Opinion, lordship will.
Opinion dated?
Opinion dated. Page 40, lordship.
And date of the opinion. Date and the case number.
Date, lordship, 39/2022.
By the opinion dated 39,
2022.
2022 in FT case number so and so.
FT case number CRD 755/2010
Of which tribunal?
of Foreigners Tribunal Jorhat.
Of the Foreigners Tribunal Jorhat had instituted WPC 8083/2022, wherein by the order dated 16/12/2022, it has been provided that if the petitioner has not yet been detained on the basis of the opinion dated 39/2022, he shall not be taken into custody and deported from India. The order also contains certain conditions as stated, provided therein. This interlocutory application is instituted on the premises that although by the order dated 16/12/2022 in WPC 8058/2022, it had been provided that a petitioner shall not be detained, shall not be taken into custody and deported from India, but on facts, the petitioner had already been taken into custody on 39/2022. In the circumstance, this interlocutory application is instituted for an order to release the petitioner from custody. As an interim order had already been passed on the premises that the petitioner has not been taken into custody, requiring him to be not taken into custody, we are of the view that as on the contrary, the petitioner had already been taken into custody, he is also entitled to an order to be released from custody. Accordingly, a release order to us, okay? Accordingly, the petitioner shall be released from custody, subjected to the common part to I allowed as indicated above. Those IRs and those they do all those.
And now, my lord, another thing is that, my lord, Choraidav, now it is Suvarnabhumi police border Choraidav. So
Full stop. As in the the interim order shall now have its effect by accepting that the petitioner is under the custody of the Suvarnabhumi police border Choraidav.
Choraidav.
Being item 1 and 2 for motion.
I think one of the grounds taken is that no inquiry was made as required under para 97 of the Muslim Mandal case. And therefore, the reference itself is not maintainable. We are hearing only on that question. Over and above, we have any other ground, we'll hear you separately. You have taken 2 grounds, I believe.
That's 2 grounds, Lordship.
And one of the ground is no
One-
inquiry,
one is-
and
one is-
so therefore under 97, this reference is not maintained.
97 as well as your Lordship's judgment in.
No, that is another issue. That we'll hear it separately also. Yes, under 97,
Lordship.
para 97.
No, the para as it-
Or you want to begin? Do you want to start?
Let,
If you want to start,
no, Lordship.
because you,
Lordship, as per.
no, we have already accepted your argument and we just want his response to it. Your argument is in view of the provisions of para 97,
Yes.
without an inquiry, no reference can be made. And
Sorry.
therefore, in this case, the reference itself is vitiated.
Yeah.
This is your argument?
Yes.
Yes. Do you want to elaborate your submission?
Subject to what my learned friends say, Lordship.
No, he'll definitely, he'll
Yeah.
make his own
I will
submission.
make a reply.
You want to give a reply. You don't want to say anything further.
At this stage, Lordship,
No.
because this is a.
Yes, Mr. Nath.
para 97, on the other day, from various angles, we have to examine. Lordship would like to examine para 97. In fact, while deciding the Muslim Mandal's Muslim Mandal reference,
Yes.
In fact, Lordship, may I make one thing clear, Lordship, before that? In fact, my answer would be specifically, although para 97, question number D, that is the judgment of Muslim Mandal.
Which page? Paragraph number?
Paragraph, it starts just before 93, about
93.
question number D.
93.
In what manner the investigation is to be carried out by the
Just a minute. Para 93.
above the question D.
Hmm.
while deciding the reference, honorable.
Para 93, it can be seen from the explanation.
No, Lordship, the language is the
Muslim-
right to get fair trial. 93 is that.
Some questions were framed. Para 93.
After 93, more 93 bill election.
Para numbers are different.
In book, Lordship, GLT, it is.
No, it will be to 93 or more 93 to bill election. Okay, well, it will division bench.
Muslim Mandal.
Full bench. Figures. Division bench. This is division bench. It is a division bench. Full bench too. No, it is a division bench. Wait. Yes.
Wait,
Para 93.
wait, before that, Lordship, the question. That is the one of the question of reference. What manner the investigation is to be carried out by the instrumentality of the state before making a reference to the tribunal under the provisions of the order 1964 order. And the subsequent paragraph, sir, answer to the reference.
While answering this question, ultimately the conclusion is para
Para
97.
97.
Para 97. But this is the question before the full bench. In what manner the investigation is to be carried out by the instrumentality of the state before making a reference to the tribunal under the provisions of the 1964 order.
Mr. Doctor, by referring this To some extent, it goes against you.
That's it.
By referring this, to some extent, it goes against you. Why I'm telling you? Just see the sentence prior to question D. The tribunal therefore would have the jurisdiction to reject such application at the threshold if no ground is made out.
It is.
This is regarding something else.
Yes.
But when providing for the same thing as an answer to question D, this similar thing is not provided.
No, Lordship, what my understanding would be, Lordship, it is in relation to setting aside an expertise order. Because Greenlink Lease Bank Limited and others judgments were referred. Elaborate discussion is made and the judgment has discussed this particular Muslim owner discuss all the judgment taken into it. And it is provided that if this line, the tribunal therefore would have this jurisdiction to reject such application at the threshold if no ground is made out. If the proceeding could not made out any ground to the satisfaction of that tribunal to set aside the expertise order. The meaning of this sentence is very specific and limited to that only. It is in relation to the setting aside of expertise order.
Yes, Mr. Nath.
Well, the question what was answered in this paragraph from 93 para 93 to 97. Well, before I take your lordship to that, well, the first and foremost would be, well, there is no specific, in my respectful submission, there is no specific provision under the 1964 order and 1964 Act, Foreigners Act and the 64 order for making a reference. There is no specific provision. If we read section 9.
No, Mr. Nath, what you were saying is interesting. This morning, somebody argued that the entire thing is reference is under section 5A of the Foreigners Order, not Foreigners Order. Is yes, Foreigners Order 1948.
Foreigners Order 1948.
Today, somebody raised an argument. We give time to the respondents to respond. I think Mr. Sharma is aware that all these references are made under section 5A of the Foreigners Order 1948.
Power to
if you are holding the same color book, it
yes,
is at page 20.
No, this is power to examine persons. Power to examine persons.
I know.
Logic. The civil authority may examine any person who seeks.
When did we fix that matter, Mr. Sharma?
After it was not fixed.
Mr. Nath, take note of that also. I think
I'll
we'll require your arguments in this.
I'll take note.
Because one argument is raised that all references, I don't, it's his argument, maybe right, maybe wrong. All references are made under section 5A of the Foreigners Order 1948.
Logic.
Okay. And section 5A provides that only civil administration can do it. Civil administration is defined under section 2(2) of the same order. So as submission is made, now all these references are made by the police authorities and not by civil administration.
It is there.
Therefore, every reference is without jurisdiction.
No.
I don't know, yes or no. We require you to make your submissions in that matter.
One argument has come. Argument has come in that line. But I have gone.
So please come when we hear that matter. I think today's item number.
Item number 4.
Today's item number 4. Please take note of that.
I'll take note of.
Okay. Now, we are responding to your submission just now that references are made under which provision?
There is no specific.
There's no specific provision to make a reference. Okay.
But in fact, if Lordship kindly takes up the Foreigners Act.
If there is no power to make a reference, then how can you make a reference?
No,
then everything is without any authority.
No, section 9, section 8 and 9. If we read section 8 and 9, section 8 provides
8 and 9 of
of the Foreigners Act 1946.
Foreigners Act, okay.
But it provides for determination of nationality,
Foreign, just a minute, Foreigners Act,
1946,
section 9,
section 8 and section 9.
8 and 9. Okay.
It provides for determination of nationality. May I read, no?
Yes, please.
Yeah, where a foreigner is recognized as a national by the law of more than one foreign country, or where for any reason it is uncertain that nationality, if any, is to be ascertained, ascribed to a foreigner, that foreigner may be treated as a national of that country with which he appears to the prescribed authority to be most closely connected for the time being in the interest of sympathy, or if he is of uncertain nationality of the country with which he was last so connected.
This is with regard to a foreigner.
This is with regard to a foreigner. Now,
We are not concerned with foreigners.
section 9.
We are concerned with a class of people, a set of people where there may be a view formed by the authorities that they have entered the state of Assam from the specified territory subsequent to 25/7/1971.
71.
We are not concerned whether they are foreigner or their nationality of which country.
True.
Whether they entered state of Assam subsequent to the cutoff date from the specified territory.
But in that case, all other cases fall under section 9. Section 9. Section 9 says if in any case not falling under section 8, the question arises with reference to this act or any order made or direction given thereunder, whether any person is or is not a foreigner of a particular class or description, the onus of providing that such person is not a foreigner or is not a foreigner of such particular class or description, as the case may be, shall notwithstanding anything contained in the Evidence Act lie upon such person. So under the provisions of the Foreigners Act 1946, a particular class has been class of person has been made, and which is envisaged in section 9, and it says that the burden of proof lies on that particular class, because these are the persons, they don't fall under section 8. These are the persons, they don't
But
fall.
this power to refer
Lordship.
is provided under Foreigners Tribunal Order 1964.
64 provides for-
That is where the power to refer is provided for.
In fact, if Lordship, I would like.
Section 9 is
Lordship.
whether a person is a foreigner or not.
Lordship.
It is burden is not on the state to prove that he is the foreigner. The burden is shifted to the person concerned to show that he is not a foreigner.
Not a foreigner.
Only it's a special law where the burden of proof normally is on the party who makes the allegation or makes the assertion. But
Makes the assertion.
here is a special case where the burden, the law has shifted to the other side, that
Right.
you show that you are not. So this is the purpose of section 9 of the Foreigners Act.
But-
But whenever it's a question as to making a reference to the tribunal, I think the Foreigners Tribunal Order 64 will govern the field.
Order.
There, these provisions of reference is made.
Okay. But now the Foreigners Tribunal Order 1964-2, it provides that constitution of tribunal.
Understand.
The central government. may
What
by
is this?
order-
Central government may by order refer the question.
Question.
So this is the power to refer. Although the heading is constitution, the substantive provision is
Lordship.
central government may by order refer the question as to whether a person is or is not a foreigner
Within the
within
meaning
the meaning of foreigner to a tribunal to be constituted for the purpose.
of purpose for its for its opinion.
So,
So,
this provision is basically an enabling provision.
it's an enabling provision
It's-
giving power to the government.
Suppose the central government has any doubt whether a person is a foreigner or not, an enabling provision is given, then you may refer it to the tribunal.
Logic.
It is not mandatory to refer also. Central government in some cases,
May.
if they feel they may not refer also,
Logic.
if they can
Logic.
deal the matter in some other manner.
Logic.
But otherwise, it may refer to the tribunal. So this is the power of making a reference.
Reference.
And who will make the reference? Central government will make the
Central
reference.
Central government may by passing a specific order, they will determine.
And how does central government do, whether by delegating it to some authority or they themselves, it is for them.
But in the system prevailing in our place, it is the central government. They have delegated the power. It is to the SP border. It is to the SP border. Now,
So this
what-
is your answer to that question 5A.
What I was trying to point out before your lordship, that as such in the act and in the particular act and in the order, there is no prescribed procedure for making a reference. A reference only, it indicates that the central government has the power. Central government may refer the matter to the tribunal and they will pass by passing for determination of the nationality.
So now
Lordship.
we'll come back at you.
Yes, yes.
Single bench also, anyway. Single bench also. Kita kuch nahi. No, nahi, kita kuch bhi bola nahi. As you really reference was it. Courts will continue up to what time? 3:15. So what is the point? Course this is what we said. Rise at 2:45. We'll sit at 2, we'll rise at 2:45. Lord Chief is having a single bench. We'll continue at 2 o'clock.
Yes, Lordship.
He's on the way.
Why not let my learned senior friend argue it? I'll submit some expect letter after his completion of the.
For whom will you appear?
My lord, I will appear for the state government.
For whom is Mr. Nath appearing?
My lord, Mr. Nath can appear for respondent number 3, my lord, the deputy commissioner for the, because government is represented by the deputy commissioner. My lord, I will appear for.
Deputy commissioner is not government, deputy
No,
commissioner.
my lord, they are representing the deputy commissioner.
I know.
Supplement privilege.
Deputy
I'll
commissioner,
just supplement some aspect, my lord.
how can you do it? In other words, two counsel will be appearing for the same respondent.
Just I will, my lord,
Whatever you want to say, you can tell Mr. Nath, he can also forward it. But otherwise, on principle, we can't allow two counsel to be appearing for the same respondents. Here we understand Mr. Nath is appearing for the Home Department. It cannot be deputy commissioner because deputy commissioner is not the appropriate authority to respond in this matter. Deputy commissioner is only a deputy commissioner. Neither he is representing the government. He cannot. We understood the difficulty, Mr. We have, in fact, we enjoy hearing Mr. Pine, but On principle, we cannot allow.
Well, I was submitting to bring home the issue before your lordship, that whether the procedure prescribed under paragraph 97 of the Muslim Mandal judgment is a mandatory provision, or the nature of its nature is mandatory, or its nature is directory. But I have started my submission by pointing out that there is no specific provision in the 1946 Act or in the 1946 order for making a reference. The reference is being made in one of the judgment. It is indicated that the central government under Rule 2A, power is vested on the central government. Central government has issued a notification
Rule 2A
of the order, 64 order,
of the Foreigners Tribunal order.
Foreigners Tribunal order. That power has been given, and under that, exercising that power, the central government has issued a notification, and herein the SP border is the authority who can make the reference. But there is no such procedure prescribed for making a reference in the not in the Act or not in the order. There is no specific as such, in as it is available in some of the acts, they making reference there. This has to be done, or this procedure has to be followed. There is no such procedure.
According to you, the Foreigners Act and the Foreigners Order of 1948 does not provide for any reference. Only Section 2A of the Foreigners Tribunal Order 1964 mentions about a reference being made.
The reference and the power has been delegated to the central government.
And there it is the power of the central government, and the central government had delegated this power to the Subordinate Police border.
SP border.
Yes.
But in the provision, there is no prescribed procedure.
Procedure is not prescribed.
Procedure is not prescribed.
Oh.
That is what I'm trying to submit. But no, I'm in the procedure. But in Muslim Mandal's case, yes, but in the case of Muslim Mandal, in the full bench, while deciding question number D, there a question was before the full bench, at just before paragraph 93. It was
in what manner the investigation is to be carried out.
Investigation is to be carried out by the instrumentality of the state before making a reference to the tribunal under the provisions of 1964 order. But ultimately, to start a proceeding, which is relatable to Section 9, because Section 8 is totally different. It is for the foreigners. Section 9, a proceeding is to be initiated. Now the reference is there as per the notification, and it is relatable to Section 9. It has to be proved. The tribunal has to decide that particular reference, and the procedure, how the tribunal will decide that particular reference coming before the tribunal. It is also given in detail how the notice will go, what evidence, that has been provided in there.
In the Foreigners Act.
In the 60,
No, we have 3 sets of statutes.
Lodge.
One is the Foreigners Act.
Logic.
2 Foreigners Order 1948.
48.
3 Foreigners Tribunal Order 1964.
1964.
64.
Logic.
These are the 3 statutes that govern the field.
Yes.
Okay.
In the 64 order, the Foreigners Tribunal Order 1964, the detailed procedure for disposal of question, whatever has come before the tribunal, it is laid down.
2 provides for constitution of the tribunal, and now this 3 provides for procedure for disposal of question. The 1 provides that the tribunal shall serve on the person to whom the question relates a copy of the main grounds on which he is alleged to be a foreigner and give him a reasonable opportunity of making a representation and producing evidence in support of his case, and after considering such evidence as may be produced and after hearing such person as may desire to be heard, the tribunal shall submit its opinion to the officer or authority specified in this.
Which one you were reading?
Rule 3,
Procedure.
Rule 3, procedure for disposal of question.
That's a mongolian, eh? Jyoti, this is the heading Constitution of Tribunal. Constitutional provision 2 or 3 है. One is not a provision related to Constitution of Tribunal. What's independent provisions beyond Constitution. Yes, gives the enabling power to the central government to refer to president. It has nothing to do with the tribunal Constitution. Mr. Nath, here we noticed one aspect.
Logic.
Foreigners Tribunal Order 1964,
Logic.
2.
2.
It begins with the heading Constitution of Tribunal.
Yes, Lord.
But if you read 2.1,
2.1.
it is not related with any constitution. 2.2 and 2.3 are related to constitution.
Well,
1 appears to be a provision independent of the heading constitution.
logic.
1 appears more to be an enabling provision by which the central government may refer a question whether a person is a foreigner or not to a tribunal
For its opinion.
to be constituted. That means when we read 2.1, tribunal is yet to be constituted,
Logic.
to be constituted.
Central government may
Then,
order.
but 2 and 3 specifically relates to constitution of the tribunal.
Logic.
So 1, we have, I think there is a principle of interpretation that the actual provision of the statute has to be taken into consideration and not the heading of that particular section.
True.
Constitution of the tribunal heading pertains only to 2.2 and 2.3.
2.3.
2.1 is independent.
One relates to.
1 is independent, enabling the central government to make a reference
Yes, Lord.
to the tribunal to be constituted.
In fact, it is relating to the. It relates to the function of the tribunal. What the
No.
tribunal will do for its opinion.
No. The function is again procedure and etc. This is, I think the central, as you say, that there is no provision to make a reference. To overcome that, there is 2.1 which enables the central government to make a reference.
Make a reference. True.
If central government is concerned with the question whether the person is a foreigner or not.
Is not a foreigner within.
So the
meaning of
central
law.
government may make a
May
reference.
make a reference. Logic. Well, the detailed procedure to be followed by the tribunal
That
is
is
given.
3.
That is 3.
That is 3.
In fact, 3.1 provide in fact, in my respectful submission, here also the arrangement of section. First, the tribunal will follow 2, 3, and subsequent the 1 provides that the tribunal shall serve on the person to whom the question relates a copy of the main grounds on which he is alleged to be foreigner and give him a reasonable opportunity of making a representation and producing evidence in support of his case. And after considering such evidence as may be produced, and after hearing such person as may desire to be heard, the tribunal shall submit its opinion to the officer
Is
or
3.1
authority.
followed? Is 3.1 anywhere followed?
No, 3.1 comes later. 2 comes first.
I know that.
Logic.
Suppose we are already in the stage of 3.
Logic.
Is 3.1 followed?
Yes, fellas. This is being followed. Otherwise,
No, because till now I have from the records, I have not come across a.
no, rule 3.3.
No,
Logic is
I'm on rule 3.1. Let's do
true.
one by
3.1.
one.
Yes.
From the records, till now, we have not come across any document by which the tribunal served on the proceedee a copy of the main grounds. I think this is given a go by, just check up. Although no one has raised this question till now. Possibly it is, just check up any of the
In
records.
in the notice, Malad, they used to indicate the reason why he has been called.
Yes. Just check up any of the records. I don't think it is ever taken up. No. Anyway, that's not before us. Please continue.
Logic. Malad, this detailed procedure is given here, and my submission is relating to this detailed procedure is, Malad, the honorable court, while passing their judgment, was conscious about the fair trial to be given to the proceeding. Fair trial, and which is the fundamental right of the proceeding, and in fact, fundamental right of every citizen in case of a fair trial. Malad, the fair trial indicated in the paragraph of the full bench, that Malad, that concept has also been brought to the Malad, it was also brought to that particular on the officer who has made reference, and on the basis of some investigation done. And this particular if we read from paragraph 93 onwards,
Right to get a fair trial.
fair trial. But a fair trial, in my respectful submission, will start when this procedure will start by the tribunal under
Once,
three.
once on and from the 3-1 stage, the trial will start.
Trial will start
Trial cannot be before 3-1.
before 3-1. Before 3-1. In fact, Malad, before 3-2, the foreigner tribunal shall serve a show cause notice on the person to whom the question relate. That is the proceeding. That is the first instance. In fact, Malad, the arrangement of section has been made in that manner. But the first point of starting is subsection 2 of section 3.
Then what about 1?
One is the broader thing, Malad. One is the broader thing, that he has to be given all opportunity and all these things. This is the detailed procedure.
No. 1, the tribunals shall serve on the person to whom question relates a
Yes, yes.
copy of the main ground
Yes, Malad.
on which he is alleged to be a foreigner.
Yes, Malad.
Now stop there.
Yes, Malad.
2, foreigners tribunal shall serve a show cause notice on the person on whom the question relates.
That is the
So
procedure.
2 services are there. 1, you serve the copy of the main grounds
Main ground.
under 3-1.
Logic.
Second service is you serve a show cause notice under 3-2.
If we
What is the meaning of very central government? Yes, madam.
If
Maybe
we-
how you understand your rules?
this both can be read together.
It appears, I think,
Yes, that is the starting point of that. That is the starting point.
for all purpose to make it easy for everybody to understand, it ought to have been one provision.
One provision, show cause notice, and the main.
Now it appears that there are 2 stages of service. It is of tribunal shall serve on the person question relates. Tribunal shall serve on the person who question relates. These are for you. A copy of the main law. Next one, a show cause notice. Big service. Do what you. Or to make it easy, Mr. Nath, we can read 1 and 2 conjointly.
Conjointly.
That what will be served is one notice, and that notice will also contain the main grounds on why he is alleged.
Logic.
I think this is to harmoniously read the 2 provisions.
Yes,
I think
That-
that's
that
very
is-
good. Otherwise it will be little absurd. One,
Two notices.
one ground will be served, wait for some time, then serve another notice,
Show cause.
then.
True, madam, true. Malad, therefore, the first point, that is why Malad, I am submitting that the first point is that show cause notice with main ground.
Hmm.
That is the first
Hmm.
point, Malad,
Hmm.
when the trial begins.
When the trial begins.
When the trial begins. Now, if lordship kindly comes to paragraph 93 onwards,
Hmm.
the question before the full bench, Malad,
Hmm.
in what manner the investigation is to be carried out by the instrumentality of the state before making a reference to the tribunal under the provision of 1964 order. This was possibly because before in the none of the order or in the act, the procedure for reference of the investigation is not laid down. It is not there. And while reciting that paragraph 93, it starts that the right to get a fair trial is a basic fundamental and human right. Any procedure which come in the way of a party in getting a fair trial would be violative of Article 14 of the Constitution. Fair trial also includes a fair investigation. The concept of fair investigation and fair trial assumes much importance in the matter of detection and deportation of foreigners under the provisions of the Act 1946.
Where is the basis of this conclusion? Fair trial also includes a fair investigation.
In the
Have you come across any basis?
Lordship, in the, in the paragraph, Lordship, 2-3 Supreme Court judgments are discussed. Because
I have seen that.
Habibullah-
Where is the principle that fair trial also includes a fair investigation?
Lordship, there are judgments, Lordship.
Please show us one.
At this stage, Lordship.
We expected you to be prepared.
No, Lordship,
Mr. Doctor, moment the council makes an argument, raises a submission, it is also expected that you are fully prepared on that submission. Because just orally stating something is.
Lordship, the 2-3 judgments are referred there. And
we have noticed
some other judgments are also there.
We have noticed everything. We are just
I
asking you,
will, along with my.
where is the principle that fair trial also includes a fair investigation? Please remain just confined to that. You please produce it as your.
Yes.
I'll produce submission.
Lordship. The concept of fair investigation and fair trial assumes much importance in the matter of detection and deportation of foreigners under the provisions of the Foreigners Act 1964 order, as well as the 2012 amendment order. Because of
What is the 2012 amendment? Any idea? Okay, please continue. Point out.
3A of my. Expert order.
So here is a question. You bring in Article 21, citizen to try to be protected. You are under the presumption that this man is a citizen. If this man is a citizen, somebody is incorrectly trying to say him to be not to be a citizen. Is it not really wrong approach? If somebody understands somebody to be not to be because of the complexity of the law says that the burden would be on that person to show you as a citizen. Why you think you are not to be a citizen? You are not again very clear on purpose. Otherwise, the presumption is every person is a citizen. There is no immigration, no illegal immigration. One of them three. Success is 230.
Amendment can I sir? See ARO for amendment on this.
The investigation that you try and proceed.
So this sorry.
Mr. Nath,
Malad.
in an investigation, under section 167, I think, CRPC,
Yes,
is there a requirement anywhere that the accused must be also given a hearing?
no,
Then how can that principle be brought in and incorporated?
in paragraph 94.
No,
95.
when it is a matter of investigating whether a person is a foreigner or not. If in a more serious offenses, the requirement of giving the accused a hearing by the investigating authority is not there. So therefore, the question of fair trial is very right. Trial has to be fair. If the investigating authority submits a charge sheet before the criminal court, the criminal court, before proceeding on trial, also decides on the question of whether the man has to be charged or not.
Yes,
So therefore, there is a stage of consideration of charge, depending on the material produced by the investigation.
true.
But where is the requirement that the accused also has to be given in a hearing? Meaning thereby, you are giving credence to the accused fleeing away from the investigation. If you run away from the investigation, you are saved. You
That
can no charge sheet can be ever filed against an accused because law gives you the opportunity to run away. So
That is-
there will be no charge sheet against an absconding accused. There will be no charge sheet against anybody. So this is a huge benefit for any person who is accused of doing anything.
Yes,
Just run away.
if that proposition is to be considered for
So
all.
ultimately, para 97 leads to that
Malad,
only.
in fact, Malad, my submission would be, apart from, Malad, the full bench has gone beyond 97. In fact, the decision made, the conclusion of the honorable full bench is at para 98. Para 98 is the ultimate decision.
No, ultimately, we are just examining 93.
Lordship.
One is fair trial also includes fair investigation.
Lordship.
Citizenship right is to be jealously protected, right
Lordship.
under 21 available to all citizens, even to non-citizens, to have fair investigation.
Lordship.
What do you mean by fair investigation?
Well, fair investigation doesn't, well, fair investigation,
Does fair investigation also mean that the person who is investigated has to be given a hearing?
no, Malad, it is unheard of. It is unheard of and it is not required at all.
But now issues are raised that I was not given a hearing. So therefore, everything is vitiated.
But that is why,
No,
Malad,
my ground is, let's say, is not that I have not given an opportunity of hearing. My ground is that rightly, wrongly, there should be an inquiry before making a reference. Inquiry may be wrong. The inquiry officer may write that I have visited the person, tried to find out the person.
And what do you mean by inquiry?
like,
What do you mean by inquiry?
Lordship,
Again,
64 rules.
Mr.
Lordship.
Dato, again, we come down to the same thing. If you mean inquiry means the inquiring authority visiting that person, that means
No,
the moment you use the word visiting, the implication thereof will be what is the effect of visiting? You'll be directly confronting that man, giving him an opportunity that here I come to investigate against you. Please say what you have to say.
Because of the
So
garden section 9, Lordship.
understand. In other words, moment that happens,
Yes.
all that the person is required to do is to, moment you see the investigating man coming
You'll flee
towards
him.
you, run away.
Yes.
Run away,
Yes.
frustrate that visiting,
Yes.
and then come back to the court and say, I was not given a fair opportunity. So,
Yes.
inquiry definitely it is there. We accept your proposition,
Yes.
saying that sitting in an office, somebody, in his imagination, he finds that X is a foreigner, refer him. that is possibly little incorrect. He'll have to make a little
Yes,
more
Lordship.
inquiry. But little more inquiry doesn't mean you'll have to visit that man, you'll have to confront him,
It
you'll
does
have to
not-
give him an
it does not.
opportunity.
It doesn't mean,
This
yes.
will fundamentally hit the proposition of investigation.
If practicably, Lordship.
Understand, Mr.
Yes.
Doctor, if we hold it in case of a foreigner, same principle will be applicable under 167 CRPC also.
Yes.
That tomorrow the IO cannot confront the accused, bring an end to that investigation. So all that the accused persons are required to do in this world is run away. Run away, that is your solution, having a stamp of authority under the law. It's little absurd.
This will be absurd, and this will well, create a situation well, which we cannot
So
think of.
two judgments are relied, Dwarka
Yes.
Prasad.
Yes, yes.
Dwarka Prasad, what he said?
Dwarka,
To write a fair trial. To get a right to a fair trial. Fair trial, we all agree.
well, fair trial is agreeable.
We all agree. Fair trial always has to be fair.
Yes,
Trial
yes,
can never be.
Lordship,
skewed.
Lordship. In fact, my lord, it was in the mind of the honorable full bench that Article 21 has to
It
be
has also been opined in Zahira Habibullah.
in Zahira Habibullah.
It has been opined that
Sir.
concept of fair trial entails entails family triangulation of interest of the accused victim, society. It has to be also find a trial which is certain that it has to be fair. Now, one more aspect of these decisions, Dwarka Prasad, Zahira Habibullah, they are all admitted citizens.
They are citizens and
So they are all persons admitted to be citizens of India.
yes, yes.
Here is a class of case where the determination itself is whether the person is a citizen or not.
Lordship.
So, in initiating a process, that is the inquiry, thereafter reference, the presumption that this person is a citizen is not there, because the determination is to be made whether he is a citizen or not. So maybe most of these observations of the rights available to a citizen, ipso facto may not be available. If you say that every right available to be a citizen should also be scrupulously made applicable, that will precede by a presumption that this person is a citizen.
That cannot be done.
Possibly the approach has to be a little different.
A little different. True. And Malad, after discussing all these things, ultimately the paragraph 98. 98 is the conclusion.
Let us read the whole thing.
Yes, yes.
They
Malad,
cannot
let
even
us read from para 94 onwards. Malad. No,
find that the fair trial constitution.
Malad. May I read from para 95. Malad. From para 95. Malad.
So every judgment referred
94 is. Malad, may I read para 94. Malad.
in National Human Rights Supra, which is this case, Goda right, having fair investigation and fair trial. Which is that decision, National Human Rights Commission.
His lordship relating to Chakma migrants.
No, national human rights is relating to Godra right.
Godhra right is list is given in the starting. my lord.
Do you have the judgment with you? To reiterate the requirement of very fair investigation and the trial.
My lord, this is 2009 6 SCC 676. Oh, sorry, 767.
In that national human rights.
Yes, yes. 2009 6 SCC 767.
Really, screen of the morning. Instead of taking up printouts for every case.
State of Gujarat.
Gujarat. Terrible, like, Chakma to bole, Chakma to bole. Very well.
It was very long. Oh, I do constrain like you. Video or everything that is limited.
Developing 2009. Two thousand nine, 766, 767. Nine. Six. Mission here also.
Say 97, whatever is provided, suppose these are good provisions. Okay, we accept to the extent that fair investigation is required. What will happen if it is not done? Will it be vitiate everything void ab initio? Or
In fact,
because that is not provided.
in fact, the last sentences in
Ah.
last part of para 97
Ah.
and paragraph 98.
Ah.
That is the
That will ensure a fair
Lordship.
investigation, submission of proper needless to the need not be detailed or exhaustive.
Needless to say, such investigation need not be detailed or an exhaustive one, keeping
Yes.
in view the nature of the proceeding before the tribunal and the objects sought to be achieved. Hence, it need not be equal
So,
with an investigation conducted in criminal cases.
Mr. Nath, in these matters, how does the authority proceed? What is the modus operandi or the procedure adopted?
There,
Yes, Mr. Pine, you can help from records of any of these cases. How it is done?
Record from this record itself.
So in this case, how it was done?
The police visited the houses. They used to visit the houses, my lord. Even in fact, case diary is recorded here. Just to assist my lord, and my lord.
Hmm.
Once the police get the information, they visit the house of the person as far as possible. The case diary is,
Visit.
yes.
So moment visit is there, that is the end of it.
Yes, case diary is recorded. Case diary is there, but available. Case diary is available there. Only one thing I want to submit, my lord. There are some formats
Hmm.
of IMDT, my lord. IMDT forms were there.
We're going step by step.
Yes. Those has been struck down by the Supreme Court, my lord.
We're coming to it.
Yeah.
Mr. Nath and Mr. Dotto,
Lordship.
this line, we are unable to get it anywhere. In National Human Rights Commission Supra Godre Right case, Apex Court reiterated requirement of having fair investigation and the trial. I've almost read the whole of the judgment, also a quick reading. Word fair investigation nowhere appears. All along the judgment is on fair trial. And fair trial, we all agree. Every trial has to be fair.
Yes.
There's no doubt about it.
That is correct.
In
But
fact,
in the guise of fair trial,
Whether,
just by bringing in one line, fair trial also includes fair investigation.
yes,
How can the principles of a fair trial be also bring into
if, yes,
the concept of investigation? And by holding so, if the accused is not given the opportunity to show his material, entire thing fails. Because this is a dangerous proposition, mind you.
what I understand.
And don't look it from the confines of only one
Yes,
matter.
Lordship, yes,
I am saying on the point
Other
of view of a proposition in law.
yes, Lordship.
Tomorrow, every accused is going to come and rely on this, say that in my case, as there was no fair investigation because the police never came to me to explain my case. And if that is the law, all it requires for the accused is to run and keep running.
Yes.
So that the investigator can never get hold of this man.
What my argument would be fair trial, they're because of collecting the basic.
All that we will uphold it 97 from the point of view that this is an enabling provision that may also require the investigator to make a visit.
Because 64 order.
Purpose is not that if you don't do it, the whole process will be vitiated. Purpose is if the accused or the proceedee wants to avail that opportunity. Suppose a particular proceedee is fair enough, he knows I am a citizen, he has all the documents. He may avail this opportunity, just see these are my documents and these documents does not conclude that I am a foreigner, kindly don't refer me. But converse,
If he evade. Yes,
he is not entitled to this benefit of this provision.
if he evades,
If
then
he evades-
even then there should be at least inquiry.
If he
And the
evades, there
inquiry
is no
officer has to
law
be
that the
stayed.
investigator has to go running after him. He'll
No,
be running away and away. Investigator will be running on and on towards him.
No,
And
that is nothing,
ultimately you can never meet. So therefore no reference.
No, that is not in the extent of
So
the.
that comes the proposition of law.
so fair investigation cannot be treated as to be a shield at the hand of.
Definitely.
No,
at the hands of
question is,
some-
Lordship,
some
whether there
constituted
is
persons.
inquiry is required or not. First question. The inquiry is there,
Mr. Doctor, again, the next question comes. What do you mean by inquiry?
Lordship.
What do you mean by inquiry? That is again
Collecting of foundational facts.
It's a-
Because
it's a-
section order 3,
Mr. Doctor, that's a very broad statement.
no, state,
What do you actually mean by
no,
inquiry?
Lordship, what I am stating.
All
order
that
3
the
of-
inquiry means is one line is there whimsically on their own whims and caprice. Para 96 of Muslim Mandal.
Yes,
Suppose today there is an investigating authority.
Yes.
He has some ill feeling against X. Let me refer him. Let me take the fun of seeing how he is subjected to a
Yes.
procedure. That may be held to be something without inquiry. But if the investigator makes the minimum of effort
Yes,
to find out,
yes.
I have noticed one X moving around.
He is suspected.
I am
yes.
having some doubts on his citizenship.
Yes,
Let's see what is available for
Yes.
him. I find nothing available. I refer him.
yes.
That is good enough.
sufficient.
That is good enough.
no, in fact, my lord, that investigating authorities recommendation is not final.
Hmm.
para 98 says that that information will come to the authority who
Will refer it.
who
He will
actually
again apply
refers.
his own
He
mind.
has to apply his own.
That is not, that should not be mechanical, and para
That's
98 says, para 98 says that he has to apply his mind.
But at
and
the same
record the
time,
reason.
conversely also, if something is done mechanically also, because this aspect is very, it will be a factual aspect, will be very difficult to
Critical.
prove.
Critical.
Whether
No,
one investigator,
Lordship is correct, but my argument is, in this case, inquiry is made only in respect of the head of the family. The order for making the inquiry is.
Mr. Doctor, that is another second issue. We will deal it separately.
Lordship.
There is already a judgment of this court.
Yes,
So that is a separate issue. Don't bring the two, mix up the two issues together.
Yes.
Let us sort out issue by issue.
One by
first.
So Malad, ultimately the referring authority, he has to apply his mind.
Lordship has prior-
Lordship is
Yes.
having
Fine.
a single bench. Will you like to continue?
Lordship may, let us continue tomorrow. Malad.
Lordship, tomorrow I have some difficulty.
Hmm. Oh,
After all the matters are over,
Tomorrow I have.
we'll
some
come at you.
difficulty.
Malad.
Tomorrow, some DB1 matters are also coming.
I have some also, Lordship.
Then on Monday, Malad.
Let it be on Monday.
Monday, after the regular matters are over, Malad, we'll come at you.
Very
We'll come at you, Lordship.
Hearing remains incomplete. Heard Mr. D. Nath and senior government advocate for the respondents in the Home Department of the Government of Assam at some length. Hearing remains inconclusive. List. Having heard in part, list again on
13th.
13.
Monday.
because this judgment, I think some observations are a little.
Like if.
Will
Lordship-
not do anything, will not take a different view, will only clarify.
If Lordship, suppose Lordship, what example is given, a person, the inquiry officer visited. He does not found the, because he is evading.
Good enough.
In that event, inquiry officer is entitled, can therefore.
Because this visiting, this inquiry is only for the basic purpose of giving an opportunity. The proceedee may avail that opportunity, he may not avail
No,
that
Lordship,
opportunity.
it is twofold. One is giving opportunity, other is to collect the foundational facts. Because in absence of foundational
There
facts,
is nothing called foundational facts.
no, in absence of,
Sorry.
if stating the grounds,
Mr.
because the
Doctor,
wording of
the
order
concept of
3.
foundational fact, we don't
No,
accept it straight away. Yes, we'll
Lordship,
continue.
it is related to order 3 of 64 order, because stating the main grounds, if nothing has been collected, whimsically just, he is a foreigner, he is suspected to be a foreigner, the tribunal cannot issue a notice stating the main grounds, because grounds has to be gathered from the materials available before the
If
tribunal.
that is so, therefore, 3(1) protects you from that. Without foundational fact, if it is done, 3(1) protects you. So therefore, the law has made adequate provisions to give protection to this
And
kind of
in
people.
fact, what
But
Lordship,
that does not mean the man cannot be referred at all.
and the judgment, Lordship, Muslim under judgment, it is because there is a legislative background, Lordship, because inquiry.
Mr. Doctor, you'll be in trouble if you take that stand.
Because it is supplemented by
Doctor,
judge-made law, Lordship.
Understand, you'll be in difficulty if you take that stand. I can,
So anyway,
we can
one-
indicate you why we are saying so.
Yeah.
That stand will be little difficulty. Because there was a legislative provision, Supreme Court has struck it down. So it's not a case that there is a legislative background. When the Supreme Court has struck down that similar provision, providing for this kind of a requirement, it cannot, it's not a case of legislative vacuum. Legislative vacuum would have been had there been no statutory provision. But prior to this judgment, there was a statutory provision.
Yes,
And prior to it, Supreme Court has struck it down. So therefore, it's not a case of legislative
It
background.
is
In fact-
basically
in fact,
on per day.
So therefore I am telling you, if you raise the question of legislative vacuum, it's directly going against
But
you.
in
No,
fact,
it is, it
everything,
stuck down basically
everything,
on section 4, because the burden as well as
Mr.
the.
Doctor, you are free to argue.
Even
Yes, yes,
inquiry
good.
for
Let's be back, Monday.
What do you think? You know whether it's-
Monday.
Malad, in fact, everything based on the presumption. And the presumption has to be reasonable. That is everything. Malad. Because the burden lies on him. Otherwise,
Otherwise, in the name of fair investigation, in the name of all kind of provisions, a situation cannot be accepted that if a man is allowed to run away, he is saved. That will be a travesty of the entire proceeding.
A question of running out is because in this case, let's say the state liberty is still there, they can again refer this person.
around 97 also,
Specifically.
they may run away, my lord. It's what sentence is.
yes, yes.